Reba McEntire. That was the selection of Senator Hatchett. He picked that song for tonight. Don't trust your soul to no backwoods southern lawyer. We all know that advice. So I'm going to call the meeting to order, and I'm going to ask Senator Hatchett, since she selected the song tonight to kick off the meeting, if you'll also kick us off with a word of prayer. Which mic are you? Number 12. If y'all please bow with us.
Let us pray. Dear Heavenly Father, thank you for allowing us to gather today. Please be with us. Please give us wisdom and guidance as we make decisions for your people. In Jesus' name I pray. Amen.
Thank you for that. We have sign-up sheets up here for the bills. If you want to be heard on the bill, please come sign up. We did not include sign-up sheets for two bills that were holdovers from the last committee hearing. We'll have substitutes in those bills that will be presented that we already took public testimony on. And so we will start, speaking of that, with SB 465. Senator Goodman, if you want to come on up. This is the bill that we heard at the last committee hearing. And we have a substitute we're working off of, which is LC 491824S. Is that what you have?
Yes, sir.
I know when the bill was presented in committee, you've worked with Lieutenant Governor's office, making some changes to the bill. You've also apparently been working the committee really well, too. And I think what I've been told, I guess we'll find out soon, the committee seems to be comfortable with the changes that you made. But if you'll tell us the changes, and then we'll open up for any discussion.
Absolutely. If you don't mind, Mr. Chairman, I'm going to have Jack Winnie, who was with me last time, present.
Yes, sir.
Thank you, Mr. Chairman and members of the committee. I'm Jack Winnie. I'm the Chief Assistant DA in the Coweta Circuit. Work for DA Herb Cranford, who's sitting behind me. I think most of y'all were here last week. So the only change to the bill was what was formerly lines 21 through 24. It's now 21 through 25, the charging subsection. Clarified a couple things. So in what is now line 22, what used to be without the intent to do so is now without the intent to cause the death of said human being. Without the intent to do so referred to causing the death before, and that's the language from the current involuntary manslaughter, felony involuntary manslaughter code section, but that clarifies that. We added by intentionally in line 23, and then the other change is it now, instead of or selling a controlled substance and so on, it's or selling any substance that is in fact a controlled substance and so on. And I think that sort of clarifies some of the concerns about the intent raised by the committee last week. And so those are the only changes to the bill, and I'm happy to take questions, Mr. Chairman, or
all right. Do we have any questions from the committee for Mr. Winnie or for Senator Goodman? Senator Hodges?
Yeah. Thank you. Thank you for the presentation. Simple question. If a 17-year-old buys a bag of pot, shares it, or sells half of it to another 17-year-old, and it's adulterated, it has fentanyl in it, 17-year-old didn't know it, and somebody dies, what happens?
So, thank you, Senator. I don't believe that would be covered by this bill because marijuana under Georgia law is not a controlled substance, counterfeit substance, or imitation controlled substance. It's a controlled substance federally, but it's not a controlled substance under Georgia law. And so the marijuana distribution that would be intended wouldn't be covered by this.
Senator Cowser.
I just wanted to thank Mr. Winnie and Lieutenant Governor's office and Senator Goodman for working on this. I believe by adding that phrase by intentionally, that eliminates the type problem Senator Hodges is worried about, even if it were Xanax, because they weren't intentionally giving, the fentanyl or whatever. But I appreciate, I wanted just to mention, you and I had a conversation, Mr. Winnie, that some of the committee members had concerns about the not less than 10 years or more than 30, whether that could be probated or suspended, and you and I understand that it can be. If you would explain that to the committee, because that example in the Athens situation, the judge would have discretion to take everything into account, and this makes it sound so harsh, not less than 10 or more than 30. Can you explain that that doesn't have to be behind bars?
Yes, thank you, Mr. Chairman. So under Georgia law, it's basically regardless of how the range of punishment is phrased, there are a couple ways it's commonly phrased, and this is a common way. There is, and I don't recall the exact code section offhand, but there's a code section that basically says that a judge has the authority to probate or suspend unless the statute says otherwise. And so that's why when there's mandatory minimum language, that is the exception to the general rule that a judge can suspend or probate any sentence. And so because there's not mandatory minimum language in this bill, the range, the 10 years could be suspended and it could be probated, and any amount of it could be.
Thank you.
All right, no other questions. What's the pleasure of the committee? A motion to pass from Senator Jones by committee substitute. Is there a second? Second from Senator Cowsert. All those in favor of the motion, please raise your hand. It is unanimous. Thank you. Appreciate your work on this.
Thank you, Mr. Chairman.
Thank you. And don't you go anywhere, because you have the next bill on the agenda. Senate Bill 474, working off of LC 442734S.
Yes,
Tell us
sir.
about this one.
Okay, well, first off, I want to thank you, Mr. Chairman, for the work that you did, and also I'd like to ask Jeff Ledford, please come up here and sit with me from the Realtors Association. What started this, Mr. Chairman, I received a purchase agreement in the mail for a piece of property that my wife and I own, 160 acres of farmland. The property appraises for $520,000. And the amount, this is a purchase agreement that I was offered, and the amount is $10,997.97. If I were to sign this, this is a legal document. And so I started reaching out to friends across my district, and y'all, these are all these kind of things that I've been getting. They've emailed them, they've sent them to me in text, they've sent them through Facebook Messenger, and people are being inundated with them. And I've been working with the Realtors Association and found out there was an elderly woman in southwest Georgia that sold 200 acres for $36,000 for this, but because of this stuff that's going on. And so we've been working on it, and we have come up with Senate Bill 474. And so just to read you the overview of the bill, there are two predatory practices concerning real property that appear to be on the rise: land wholesaler solicitations and fraudulent deed recordings. In the wholesale solicitation, the landowner receives a solicitation to purchase their property. Often this solicitation is far below market value and is accompanied by a purchase and sale agreement. Many of these solicitations target the elderly and prey upon the unawareness of the true value of their land. In the fraudulent deed recording scenario, a fraudster records a false deed or otherwise fraudulently executes a transfer by recording a forged quitclaim deed. So in SB 474, Section 1, requires that mandates that a disclosure that this offer may or may not be market value. It further requires an explicit statement if the offer is below the most recently published value as established by the county assessor for taxation purposes. Also, anyone preying upon the elderly in such a manner could face a $50,000 fine, 20 years jail time, but be required to pay 3 times the most recently published fair market value of the property to the harmed party. Section 2, the contracts that accompany these unsolicited offers are void and unenforceable on their face. So that elderly woman, if this bill had been in the law, would not have had her 200 acres stolen from her. Section 3, this bill would also make it more difficult to file fraudulent deeds by requiring anyone filing a deed to provide a validation of identity. Certain institutions and licensed professionals that regularly file deeds and are already sufficiently regulated would be able to continue to record deeds as they do now. The filing of fraudulent deeds would carry the current penalties under the Mortgage Fraud Act and require the filer to pay 3 times the most recently published fair market value of the property to the harmed party. one of the things that I'm hoping for is so many of these offers are below the county assessed tax values, and people are getting inundated with them, 2 and 3 a week. I'm sure some of y'all have gotten text messages and things like that. I'm hoping that by these folks having to do some research, that it's going to slow this down a little bit, and especially when the offer, you know, we're trying to protect vulnerable people here, is what we're trying to do, you all have we have a friendly amendment, the Section 3. I believe all of y'all have it in your folder. I hope you do. It didn't make it into this final draft that you have here, LC 442734S. But the amendment we've got replaces Section 3, and what it really does is just where it says, for instance, on line 54, it says the individual presenting the deed or other instrument shall, and it'll be indicate rather than attest under oath. And so that's where we work with our clerk of courts to try to address this. Be glad to take any questions, Mr. Chairman.
So you're asking that the printout you gave us completely replace Section 3 in your bill with this language?
That's correct, Mr. Chairman.
And this is something that the clerks have worked with you on?
Mm-hmm.
Are they good with this change?
We hope
Are
so.
they here? I don't know if they're here. Okay.
We
Well,
hope
if they're
so.
not, they'll tell us tonight.
I'm sure.
Okay.
But we have worked diligently with them and have gone through several drafts trying to,
Yeah.
yeah.
All right. Any questions from the committee for the author? Mr. Ledford?
Sure. Well, I mean, there's not a whole lot to add about the harm. I think you know what's happening. We had something brought to our attention. One of the most recent ones I've had brought to our attention was someone who had a constituent. They were 97 years old, and this addresses the deed side of this. They had their property, a deed had been attempted to have been filed through the mail. Fortunately, that Superior Court clerk called the family and said, I don't know that your 97-year-old father is, I can't imagine him signing over his land to someone that lives in Washington State. And so they were able to stop it. But what they found was that this person regularly would send out a claim to a deed. He would do it, quick claim it over. He would, it was basically a fraudulent filing, and would try to extort $75,000 from this elderly couple to undo what he had done. This would make that, right now, a fraudulent deed is already under the Mortgage Fraud Act illegal. It's something you can face some of these penalties. The reason we're adding the damages here is it doesn't help that elderly couple, the amount they had to pay in legal fees to fix that problem, to go through the process to undo some things some other stuff that had been done with it, can really add up. And so that's where those lines come in about the recovering those costs.
And also, if I may,
Yeah.
Mr. Chairman, the instance he's talking about was in a small rural county where people know each other. Obviously, that's not in a lot of places. But the elderly gentleman also received something in the mail demanding $75,000 from the fraudster to transfer his land back to him.
Yeah.
So that's one of the reasons we're trying to address this issue with quitclaim deeds. And
Sure.
All right. Any questions from the committee? No one else signed to speak on the bill. What's the pleasure of the committee? Motion to pass from Senator Kenny. Is there a second? Second from Senator Hatchett. All those, and it's by committee substitute. Yes, sir.
With the
Amendment.
with the amendment.
Thank you.
When you look at, I guess, A through I, A and B, it says A licensed to practice law in the state and A licensed under Chapter 40. I think it just should be licensed, so just strike the A.
Scriveners, yeah.
Yep. So I'd like to make this amendment with those changes that I...
All right. As Ledge Counsel, are you comfortable with how we're handling the amendment?
There's a couple of other.
Let me turn your mic on, okay? You grab mic 1.
There's a couple of other changes that I've noticed. There's musts are used throughout the bill where we use shalls. Also, wherever it says pursuant to this section, we change that to code section. I believe that's all I have noticed so far. And there's an or at the end of paragraph H that has been left off. That's all I've noticed so far.
Okay. Senator Hatchett.
There's also an extra comma on subsection G. It says Title VII, comma, and then semicolon. Just take that comma out.
Have you been able to, alleged counsel, been able to read this enough to see if there's any other changes that need to be made at this time, other than what's been indicated? Have you had time to review this?
I have 2 paragraphs away, so if you give me just
Yep.
one moment.
Okay.
Chairman, I'm comfortable with the changes we made.
Okay, thank you, Ben. Senator Hatchett, do you want to offer that amendment with the changes that have been referenced by you and by alleged counsel?
So moved, Mr. Chairman.
Is there a second? Second from Senator Kennedy. Any discussion on the amendment? All those in favor of the amendment, please say aye. It is unanimous. Going back to underline, motion to pass by committee substitute now as amended. All those in favor, please raise your hand. It is unanimous. Two
Thank
for
you.
two tonight.
Thank you, Mr. Chairman. Thank you, members of the committee.
Thank you. All right, back on the agenda, Senate Bill 347, Senator Anavatarte. There you are. You had to bring a House member to help you? You don't even have your badge on. Are you still in the Senate?
Most days.
Most
Mr.
days.
Chairman.
You know, it's illegal to go around this building without your badge on. In the Judiciary Committee, we follow the law. We have law enforcement, and you're within some of their jurisdictions, I think.
Well, I think most people on this committee would probably file a lawsuit if they could anyway. So it's okay.
Well, thank you for bringing the bill tonight, and there'll be another hearing tomorrow maybe, so we'll see you then. All right.
All right, let's go, Tyler.
Is that how it goes in the House, Tyler? Excuse me, Mr. Chairman. I'll have bills in front of you soon.
You know, Mr. Chairman, we just try to be as accommodating as we can. So
I understand. All right, we have Senate Bill 347, LC 491552. The floor is yours.
Thank you, Mr. Chairman and committee. I do want to thank my brother from Haralson County, Representative Smith, Chairman Smith, for being here today. As we ask and request in this bill, a third judge for the Tallapoosa Judicial Circuit that I represent and Chairman Smith represents in both Polk County and Haralson County. With me, I do have a letter from our senior judge, Judge Mark Murphy, and our newest junior judge, Judge Andrew Roper, in support of this legislation. I'm going to let Chairman Smith kind of walk through some of the pieces and experiences that I think we're experiencing from a caseload perspective over the last couple of years, and I'll hand this letter around for the committee so y'all have it. So I'll turn it over to you, Chairman Smith.
thank you, Senator. Thank you, Mr. Chairman, members of the committee. It's been a while since I've been with y'all. Miss seeing all of y'all, but I wanted to come today. I am one of those lawyers that actually practices in this circuit. This is my home circuit. This is a circuit I've sworn in to practice law in. I can tell you that before the pandemic, we had a huge caseload that thankfully Judge Mark Murphy was able to make a pretty good sized dent in. Then we have COVID. Thankfully, they have been able to move a lot of those cases. However, with the increased amount of cases, as you'll see in Judge Murphy's very well detailed letter outlining the issues that we have, you can see that we're a little judge poor over there. When you look at the numbers, and I understand that we ranked a little low according to the study, and I understand that, but you look at the study, and I would guide you to page 2 of this letter. The additional 532 new cases over and above what the Judicial Council has determined is a maximum workload for an active Superior Court judge is frightening. It's frightening to me as a practitioner as well as a citizen in the administrative of justice in Haralson and Polk counties. Both counties, even though I only represent one in this circuit, both of these counties hold a dear place in my heart. I was baptized in New Harley Creek up in Polk County. And I can tell you that even during the pandemic, those cases that were being indicted, those that were being arrested, that didn't stop. And so we just continue this groundswell, as you see the judges outlined here for you. So we believe that an additional Superior Court judge would be the way to go. I know sometimes people may try to use this sort of situation to get a state court judge. That's a much more costly endeavor than just adding a Superior Court judge. So with that, I can tell you that having practiced in this circuit for many years now, this is a huge need for us in the Tallapoosa circuit to make sure that victims as well as defendants receive justice, as well as those that are seeking civil justice remedies as well. And Mr. Chairman, with that, I'll stand for any questions y'all may have.
Any questions from the committee for the author or the senator that sits in front of us?
I would add, Mr. Chairman, before I forget, because I know I've talked with Judge Murphy about this at length. I think that we had some capital cases that for some reason were not added to this calculation. I know several of those have been added this year alone, so wanted to make sure that that would potentially skew our ranking on that report.
All right. Questions from the committee? All right. Nobody else signed up to speak on the bill. What's the pleasure of the committee? Wait a minute. I think someone did sign up to speak. This one? No. Never mind. No one signed up to speak on the bill. What's the pleasure of the committee? Motion to pass from Senator Watson. Is there a second? Second from Senator Hodges. All those in favor of the motion, please raise your hand. 1, 2, 3. It's 5. Are you voting yes? Oh, it's unanimous. Sorry. I thought they weren't voting. All right.
Thank you.
Bill passes. Thank you.
Thank you, Mr. Chairman. We look forward
Thank
to
you.
seeing you pretty soon.
I hope
in
to
our
come visit
committee.
you soon in your
Yes,
committee,
sir.
hopefully if I'm allowed to. So.
I would say you're allowed, Senator.
Thank you.
So thank y'all.
Thank you all.
All right, thank you. Next bill on the agenda is Senate Bill 391. Senator Williams from the now Henry County delegation as well.
Thank you.
Good to have you in Judiciary. Got a pretty thick bill here about an exciting subject.
Thank you, Mr. Chairman, members of the committee.
Are you working off LC 550167?
Yes, sir, I am.
All right, the floor is yours.
Thank you very much. This bill came about from a situation up in North Georgia that came to a head just a few months ago where some people owned some property and decided they didn't want a family cemetery on it anymore, so they took it upon themselves to just go and disturb the cemetery. They removed markers, and we're going to remove graves, but the families got together and had to hire an attorney to get a stop order to prevent more desecration of the cemetery. What this bill does, and through my 50-plus years of practicing, I've had numerous counties throughout the state contact me to ask me how would a family establish a cemetery on their property. And there's nothing uniform throughout the state. So that's what this bill is seeking to do, is put guidelines throughout the state. I think there's less than a dozen counties that actually had anything in their records on how to establish a family cemetery. But this also goes over how to request a permit for disinterment, reinterment of human remains, and also to allow people to visit their cemeteries, their family There was a state representative. His family is buried down in Burke County, and the family's been able to visit and maintain that old family cemetery for many years. His great-great-grandfather, who had fought in Civil War, is buried there. This farmland was sold to some people from another state. They fenced off all the property, put up no trespassing signs. So the family is no longer allowed to maintain that family cemetery or keep it up or even visit the graves. This bill would also allow that. It also sets safety standards that anybody that wants to establish a cemetery on their property, that they are not within 100 feet of the water well of their drinking supply. This is public safety that a lot of people are not aware of, and this has been around, but a lot of counties are not even aware of that. This also sets up a standard procedure for moving graves, and be glad to answer any questions if anyone has any questions.
Senator Hatchett.
Thank you, Mr. Chairman. Senator Williams, you and I have spoken about this line offline, and there was a concern up in my neck of the woods with some funeral owners in the corner up there about line 502, about the requirement for an outer burial container, number one, and number two, being buried at least 5 feet below ground. In some parts of, just say Rabun County, the ground's pretty hard. It's rock. It's hard. Sometimes it's more difficult to get 5 feet. And then also the issue with the outer burial container. Would you be friendly to an amendment to strike line 502 at this point?
Yes, sir. I would like to point out the reasoning for that.
Okay.
But I would like to discuss it, but I will be amiable to that. The outer burial container, the reason for that request was so if those graves are ever moved, a funeral home, funeral director, family can come in and simply remove the vault, and the grave contents would be in that vault. Without the burial vault, the family is going to have to pay for an archaeologist to come in and make sure that all of the human remains are removed from that grave before that grave can be completely moved. The other reason for the 5 feet below ground is, and what I understand in talking to this funeral director there, and I understand a lot of the families up there just wish to bury people in a shroud, not even in a casket. But what you also have is wild animals that will burrow when they smell this, and they will excavate and dig down. And that was the reason for a depth. And I'll go with your recommendation, but I just wanted to give you my reasoning for that because I have seen that happen. There's a segment of our population that leaves their burial vaults up with the top of the ground. And they use the top of the vault as a ledger, as a grave marker. And sometimes those get run over by tractor. I've even had a pulpwood truck run through a cemetery like that in Irwinton, Georgia about 20 years ago. It was a nightmare of what all we had to replace and repair. So just wanted to point that out, but yes, sir, I'll go along with that, please. Thank you.
Thank you.
Senator Kennedy.
Thank you, Mr. Chairman. Senator, from the cover sheet, it indicates that the bill provides land access rights for descendants seeking to access remains on another's land. Can you direct me to where in the bill that is? Well, first of all, kind of explain to me how that works in your bill, and then maybe tell me where that's found here.
Yes, sir. I'll try to find it. I'm sorry. The reason for this is, like I was talking about Representative Jesse Petrie, not having access. So now, under this bill, when a family decides they want to establish a cemetery on their property, they have to get it surveyed, they have to get it platted and recorded in the courthouse where that cemetery is going to be on that property, and provide in that recording where access would be to that cemetery on that property. So in generations to come, it's clearly in that deed and in that plat recorded at the courthouse how descendants may approach that cemetery to maintain it, care for it.
Okay, that makes perfect sense. So there's nothing in this bill addresses or touches upon current family cemeteries?
No, sir.
Okay, and so there's nothing about this bill that affects a landowner's adjacent property rights such that a family would be given rights of access over their property to get to a current family cemetery?
It addresses that in here that,
Can you tell me where you are when you find it?
yes, sir, I
Thank you.
will, that, I'm
25?
sorry.
Okay.
In here, it's,
You might be referring to line 588.
yeah, on page 25, 44-10-52, access.
Okay.
And it says, when granting an order, or the Superior Court may authorize entry upon the land for the purpose of discovering the existence of human remains therein and conducting genealogical research with respect to any such human remains, specify the dates and hours that entry upon the land may occur, and impose any limitations on the ability to enter such land to prevent unreasonable interference with the use and enjoyment of such land by the owner thereof. So it would be working with the owner of the property to allow the descendants to access the property, to maintain, to photograph the monuments, to maintain the cemetery. So it would still, the landowner would have the rights, and it would just work out something amicable through the court that would allow them to visit the cemetery.
Sounds good. Thank you for that.
Thank you, sir.
Yes, sir. Thank you.
Is it Senator Jones or Senator Setzler? Senator Rhett, one of y'all? All right. Any other questions from the committee? We have one person signed up to speak for the bill, Cliff Dempsey with GCA State Board. If you want to come on up, you can sit tight if you want, Senator. Good evening.
Good evening. Thank you, Mr. Chairman, committee members. My name's Cliff Dempsey, and I'm a third-generation cemeterian here in Georgia. I own 3 cemeteries and a funeral home and cremation center in North Georgia. I also sit on the State Board of Cemeterians since 2008, and also am the legislative chair of the Georgia Cemetery Association. I've been the legislative chair for about 24 years, so I look younger than I am, Rick. But I am here wearing 2 hats. One from the State Board standpoint, and we are in favor of this bill that Senator Williams has drafted. We get an enormous amount of people contacting the Secretary of State's office complaining about things like that's addressed in this bill. Unfortunately, we cannot do anything about it because we only regulate the 216 perpetual care cemeteries in the state. There's close to about 8,000 cemeteries or burial sites in the state. So there's only about 216 that are actually regulated through the Secretary of State's office. So this bill would really help sort of bring some strength to those archaeological sites that are out there, burial sites that may or may, are just mainly family sites, but also to those that are wanting to plan, but also developers who might want some property and they need to know something to do with those burial sites and those family cemeteries. The other hat is from the Georgia Cemetery Association. We represent about 100 of those perpetual care cemeteries. And we definitely are in support of this bill because, once again, we receive complaints as well and comments from others wanting family cemeteries or knowing what to do with family cemeteries or how to maintain them. And once again, we don't have much leeway to help them that way. So with that, we are certainly in favor of this bill.
Thank you, Mr. Dempsey. Any questions for him from the committee? All right, thank you. Nobody else signed up to speak on the bill. What's the pleasure of the committee? A motion to pass from Senator Rhett. Do we have a second? Second from Senator Kennedy. All those in favor of the motion, please raise your hand.
Got it.
Wait, I'm forgetting amendments. Do we have any amendments? Senator Hatchett.
Yes, Mr. Chairman, I'd like to strike line 502 and
All
make
right.
the conforming changes necessary. Line 502.
Line 502. And there will be other changes necessary to effectuate the striking. So you would replace the B on line 503 with A and the C on line 504 with B. Is that what we have to do?
This is the first time I've ever seen this bill as I'm filling in, but it seems like if you were to strike completely paragraph A, that it would then potentially require entombment in a mausoleum or a columbarium.
Right.
So I believe you would want to replace, and this is line A with something like interred in a plot to remove the specific requirements.
Yep. You agree, Senator Hatchett?
I agree with that.
So which language do you want to go with?
I think interred in a plot, if the author
Does that work for you, Senator?
is.
And you might put that it's permanently marked in a manner. Would that work?
That works.
Interred in a plot that is permanently marked. Ben, does that work?
That language is a policy decision,
Right.
Chairman.
That's good. I guess a good answer. Senator Hatch, is that what you want to do? Permanently marked? You want to add that in there as well? Senator Kennedy?
Just a question.
We're all
Is there
undertakers
anything-
tonight.
Yeah. Is there anything in the law right now, Senator, that requires that burial plots be marked, permanently marked? Is that something new that we're
No,
introducing?
That's actually under cemetery rules, regulations. When you're going into a cemetery, whether it be municipal or a private cemetery, they want it to be marked. But if it's not going to be, well, I don't guess it matters. You could strike that. I've actually seen cadaver dogs that can go find graves that are not marked, so you can.
I don't have an objection to it. I just wondered, were
Yeah.
we putting a significant additional
Could we say
burden?
something like interred in a, I forgot the word we're looking at, in a, was it plot, consistent with Georgia law or something like that would be required with any other rules? Senator Hatchett, help me out.
If I may, I will
Please.
I will withdraw my amendment because I think we may need to discuss, like you said, the policy considerations that could go if the author will just work with me.
Good as a
and
floor
get friendly
amendment?
floor amendment.
Sure. that'll
I'm
be
comfortable
fine.
with that if everybody else is.
Okay.
All right. Any other amendments? Back to the motion, do pass. All those in favor of the motion, please raise your hand. It is once again unanimous. Thank you, Senator.
Thank you. Thank you, committee, Mr. Chairman.
Thank you. All right, I'm going to come down and present the next two bills. I'm going to let Senator Calzert come up and take over for me. We'll go to Senate Bill 283. Switch seats for better luck this time, or let's do that? Make sure I put the right bill.
I'm well aware.
Thank you very much.
You ready, Mr. Chairman?
I am ready for you, and I believe that we have already taken testimony on this bill. The last meeting, pretty extensive. I may ask if we have people that have an opinion to let them just sort of stand or something and let us know. But if you'll tell us any changes you have in the committee sub to help us.
Yes, sir.
get educated.
And I know some people did not come the other night and asked if they could speak tonight. I told them we were not taking additional public testimony. You may still recognize people just to say they're here for the bill. I took the concerns that, well, some of the questions that the committee had, plus concerns from other people that work with us around here. And we have a substitute LC 520502S. This, again, is the Pregnancy Protection Act we discussed at the last hearing. What you'll see we did, and we'll walk through some changes and ask Amanda to correct me if I missed something. We tightened up the language when it comes to an applicant, and we actually removed the applicant language altogether to tighten it up where it has to be. You'll see now under claimant, the word applicant is now moved there. It has to be a pregnant job applicant to bring that in. That way someone's not, as an applicant, presenting scenarios for something 10 years down the road, potentially. We also tightened up lines 21 through 23. Employee now uses that definition that we have elsewhere in Georgia law for what qualifies as what I would call a W-2 employee, someone that provides services directly, works directly for a company. We also, looking at line 38 and 39, one of the things that was brought up is you had this defense that a business could raise of the undue burden. And someone from the business community said, well, that defense may go all the way to the jury trial, and they're trying to raise this defense at trial, which is too late, all the expense they would incur. So we listed that as a, excuse me, I used the wrong line 41 through 42. That is now an affirmative defense, which means for those of y'all who understand the practice of law directly, how it works in litigation, a motion to dismiss could be filed that would address an undue burden for a company that if it was a frivolous suit, well, the undue hardship, I said burden, undue hardship is so difficult that could be addressed early on in a lawsuit. Backing up, we also added on lines 38 through 39 to make sure any accommodations that are allowed for this bill are things that are consistent with Georgia law, acts that are legal here in the state of Georgia. Senator Hatchett asked me about, maybe it was Senator Watson, if I was going to take advantage of this, and we have cleared that up, that it is her own pregnancy. Her own pregnancy you'll see listed at least 4 times here in lines 47 through 58. This is meant for a mother, a new mother, or a pregnant mother, expectant mother, or someone just went through a pregnancy. You see similar language on line 69. Let's see. One thing that was brought up from the business community is, so this all comes into effect when an applicant or employee notifies a business of an accommodation, but never says when that stops. And so we have it where now an employee has the burden of saying now I no longer need that accommodation, just to clear that up under Georgia law. I think, Amanda, did I miss any changes?
No, I think that was the... yeah, we also added in with the employer, we put in the timeline for when to determine the 10 employees.
Right.
So that made that a little clearer as well.
So line 27 and line 28.
Yes.
So I hope we hit the right balance. Again, our goal is to try to offset the inequities that happen for a new mother versus a new father, as I said in my testimony, in the workplace, working mothers, people that, ladies that are going through a pregnancy, dealing with the challenges that come with work, trying to have that right balance to make sure they're protected under Georgia law, and that we're a state that is very welcoming and encouraging for working mothers. So happy to take any questions.
Any questions from committee members? All right, you made the comment that there may have been a few people that had wanted to be heard. Wait, I do have a question. Is that Senator Rett? You got a question? Okay. Somebody at number 6. Nope. All right.
Hey, Mr. Chairman.
Go right ahead. I think I got you.
I'm following up on some just for clarity. You know, we seek clarity, then we try to get to agreement. It was raised by the pro tem in our previous hearing about this issue of a right of action, that if somebody is you know, there's, and I don't do work in an employment setting much, but there's a 180-day period after which you're sort of vested in a way and you're able to kind of bring an action against an employer. And this changes that from 180 days to immediately upon hire. Is that the policy intention in this?
I would say yes, right.
Well, so there's not a vesting period of 180 days. There's a time limit that you have to bring the claim, which the 180 days often overlaps with the woman's pregnancy, and so there's not the ability to do so. So what this does is allow a woman to finish her pregnancy and within 2 years of the act, the incident, or the violation, to be able to do something. That's consistent with what the other states have done as well. Texas just increased their statute of limitations. Florida has 4 years.
Okay. What I was asking specifically is when you start the job, and I don't practice law and I don't practice labor law. So when you start the job and you've been there a week, are you able to bring any claim that you could bring after you've been there for a year under traditional law? Is it? I mean, did I misunderstand the discussion from last hearing? That there's some period of time in which you have to be employed with a company before you can bring a case. Or did I hear that wrong?
In this, you can even be an applicant and not an employee.
As long as you're pregnant.
Yeah, this would actually also extend to some applicants as well. And so, no, it goes down to the reasonable accommodation. So to answer your question, there's no shot clock, there's no vesting period. So a new employee that asks for a reasonable accommodation could actually make a claim under this code section if adopted.
But there isn't, the 180 days is a time limit in federal law, but there isn't any case law that requires a vesting period for, or an amount of time to be.
So I made a technical mistake in saying vesting period. Is there such a thing under current law today that you have the same rights when you first get hired on that you might have later in your employment tenure? And does this change that? Because I know, because we're, in my simple-minded way, we're operating under a largely federal rubric with respect to these kinds of issues today, and we're creating a state rubric, but we're not copying everything over. Where some things are kind of start created from scratch. I just want to make sure I understand what the differences are, and I do have one other question, Mr. Chairman.
All right, go right ahead.
My other question was, and I hate to go there. I have it was raised, and I've looked at this about the kinds of things that we're bringing in by, and I know it's not the author's intention. I would certainly be happier if we had some language that was clear about this. When you think about pregnancy-based accommodations in a workplace, and employers' duties to provide this service or that service, a very broad array of things. I want to make sure, and again, if it's not the policy objective, then we could be able to say it here, because I know it's not the author's intention. I'm concerned that an accommodation may be, hey, we've created this parallel law which has a civil rights level of impetus to it, that we're creating a right of, and I know it's not the author's intention, but are we not creating an opportunity for a woman to say, a workplace accommodation for me that's provided by my employer is, I want to terminate my pregnancy so I can move on with life. It becomes an issue for that rather than combination A, B, C, or D, would we be wise to say here that nothing in this chapter shall be construed to allow an abortion that's not otherwise prohibited, that would otherwise be prohibited under,
We did that. So look at lines 38 through 39 of the sub.
Okay.
That was the intention, just to make sure we were clear. I don't think, in speaking with everyone that's worked on this bill, that would be an unreasonable accommodation by law. But lawyers argue things, right? And so to be clear, we did add lines 38 through 39 that we're not going to have someone that wants to travel out of state to do something that you couldn't do in Georgia and say that's an accommodation.
Yeah, I appreciate the chair's, consideration. That I just don't. I'm just not made real. 38 and 39 don't give me great confidence, given there is I think no matter which side of the question you're on, there is such passion. We have corporations all around the state that are funding out-of-state transport for purposes of, quote, abortion care, whatever term you'd give it. I think we need to be careful as a committee in what we're setting up here, and I don't know that this does it, but I appreciate the consideration of the chair. And if that is a policy objective, maybe the committee ought to be more specific about it. But
If you have other language you want to propose, I'm happy to work with you on, but that's the intent of lines 38 to 39, just to clarify that point.
Thank you, Mr. Chair.
All righty. Senator Watson?
Thank you, Mr. Chairman. When we heard this last time, we were discussing there's federal legislation that covers this, and this will be state legislation that covers this. I was a little unclear relating to the caps that the feds do, and it doesn't seem lines 107 to 111. There don't seem to be any caps at all on this. Even line 110, compensatory damages, punitive damages, attorney's fees, court costs, and other related expenses. I would feel more comfortable if we had, put in this caps like they do in the feds.
Yeah, I'll tell you, and I'll let Amanda speak on it. I'm just not a fan of the caps because it prejudges the case, and I think it tries to determine in advance the cost of not providing accommodation. And for a larger corporation, you can make the decision just to pay the cap.
Well, you can also make. I think the federal law has that in it, the size of the number of employees, and the caps based on the size of the employer. Isn't that right?
Is that true?
There is, Senator, and I would say, and this is a different kind of case. So when an employer fires an employee because they're pregnant, because they've asked for a reasonable accommodation to protect the health of their unborn child, that is an intentional act. It's not a mistake. It's not negligence, and it's something that's 100% preventable. And that's the point of having the damages and a remedy, is to prevent future discrimination.
No argument there. I agree with you 100%. But if the feds have 500 employees and $300,000.
So what happened in 1991 is that the reason that those damages were added to Title VII was to prevent sexual harassment. That was the purpose of the law, because until 1991, there was not any remedy for sexual harassment. What we know is that those caps did not work. From 1991 until 3 years ago, when the Me Too movement started, it did not prevent discrimination. So putting caps on damages in this bill is going to tell the Georgia workers that there is not a desire to actually prevent discrimination in this bill, but that it's just to ameliorate.
So those 10 cases a year here, averaging across the United States, So
those are under the pregnancy, the new law that came, the Pregnancy Fairness Workers Protection Act. Yes, all of those laws actually mirror the Title VII damages. There hasn't been movement or anything on since 1991 to change those damages. There is right now movement in Congress to eliminate those damages, bipartisan support on that.
Also, and correct me if I'm wrong, I'm not saying you, Dr. Watson, but somebody else. I don't think there's anywhere else in Georgia law where we have those types of caps on our damages. There is caps on punitive damages, which will be built in here. Yeah. And I think Senator Hatchick was at $250,000, told me last hearing. So that's capped by law. Yeah. Attorney's fees are capped based on determination of reasonableness.
So we have a federal law that covers this, and you don't like the federal system. I get that. It's a little bit more stringent and difficult. But they have caps. I'm not sure I feel comfortable with that without caps.
That's fair.
Yeah, I get it.
Well, Senator Kennedy, you're recognized for a question.
Thank you, Mr. Chairman. Can you direct my attention to the bill where there's a 2-year statute of limitations in which to bring the action?
It's line 102.
Okay. So,
and 104.
Thank you. I guess what I'm wondering, help me understand the policy thought behind the difference here, which is a standard tort 2-year statute of limitations, versus what we discussed at the last hearing and what Senator Setzler was bringing up about what would be a normal EEOC claim route of the 180 days and that path. And what I'm concerned about is I agree with you in this regard, well, many regards, but this is a different type cause of action that would be new for us in Georgia. And I'm concerned about if there's a 2-year window in which to bring a cause of action. That seems counterintuitive to what we're really trying to do here, which is make sure that employers treat pregnant women in a way that's, let's just call it fair and right, okay? But there's embedded in that, for this to work, seems to be there ought to be a sense of urgency, that if employers are not doing that, which they should be doing, they ought to be called out quickly so they can make the corrections quickly, so those same type harms or bad behaviors aren't visited on other pregnant women or pregnant applicants or pregnant employees. And so that, plus secondly, if you would address, especially when you're talking about accommodations, it seems to me like we're potentially complicating that issue greatly if we're going to leave a 2-year window in which we're now going to be looking back 22 months ago of what was done, and now we just kind of left an exposure there for the harm to continue or the bad behavior of an employer not to be corrected. And so, because obviously the pregnancy is generally assumed not to go to beyond 9 months, so right, the condition, if you will, is one that naturally resolves, if you will, unlike a typical PI case where you can have an injury that then is carried on for life. And so those differences make me wonder about this 2-year statute. Can you speak to some of that, please?
Yeah, the bill really sets up an interactive process as opposed to forcing somebody very quickly into having to file litigation or file with the EOC. So you start with there's supposed to be the employee who is asking for the accommodation. Then you have the employer who's supposed to respond to that, and they're supposed to engage in an interactive process. That takes time, and it might take the full 9 months. It may be that it's after the pregnancy when there's an accommodation that's needed for breastfeeding or for whatever it might happen. After the pregnancy. And so what this does is, instead of forcing people into litigation right off the bat, it really forces them into being into that interactive process, so that rather than quickly having to move into something, if it doesn't end up resolving in the future, that then you're able to do something. And really the biggest problem with the 180 days is the overlap with the pregnancy. So you've got the decision that you have to make as a woman about whether or not to be protecting your pregnancy, protecting your child, or protecting your job. And that's really an untenable position for a woman to be in. So by having this interaction in here, it actually allows for employers to remedy the situation. And if it's remedied, then there's no reason to bring the claim at any point.
But what do we do Mr. Chairman, may I follow up?
Yes, go right ahead.
But what do we do in the situation where the accommodation is made, but the woman doesn't think that it's adequate, but continues to work under, let's assume it's circumstances most would agree it's not an adequate accommodation. And then so she continues to work, and then 21, 22, 23 months go by, and then a lawsuit is filed, and now they're litigating over the appropriateness of the accommodation that was made. That's not quite as clear a set of circumstances for litigation as what you just described.
It would not be an ideal case to bring either. So, in that circumstance.
Well, but it's not ideal in part because now all the evidence is old. The behavior may have continued. It may not have continued. The people that were there that were engaging in the bad behavior may have moved on. I'm just concerned about that.
At that point, she would not have engaged in the interactive process, right? So the process is interactive, meaning that if the accommodation is not reasonable, it switches back to the employee to continue to have those conversations. It's not just a one-sided conversation. So if somebody stayed and waited for 2 years and accepted accommodation and then came back later without continuing their part of it, they wouldn't have a claim the way the statute's written. So really it's about putting employers and employees into a situation where they're working together as opposed to moving into litigation at some future point.
Okay.
And that's my only fear. I hear you on the 2 years, but I'm afraid if we do it too short, you would just encourage immediate lawsuit to be filed to preserve your claim, and you get in litigation mode right away. That's my fear. As I hear what you're saying,
yeah,
but I almost feel like it may invite more litigation, and that's not my goal with the bill. But
right, and I understand having too short of a fuse, people would
you just file a suit just to be safe.
Yeah, and so I'm not sure exactly where that balance is,
right.
But I absolutely recognize what you're saying.
Yeah, the other states that have done this have gone to 4 years or even longer in some of the other states that are out there. But like Texas is 4 years, Florida goes up to 4 years. But practically speaking right now, when you go to the EOC, it's taking you far longer than 2 years before you're actually going to get the right to sue and be in litigation if you're waiting for the process to happen. And so you're really at a more unfair advantage as an employer or even as an employee when you're dealing with the process right now, having to go that quickly at 180 days.
Thank you. Mr. Chairman, one more question.
Go ahead.
So I want to pick up on Chairman Watson's question about caps, because I'm interested in perhaps that as well. And I want to take issue with something you said, that all a cap does is send the message that Georgia's not serious about dealing with these violations. And I would disagree, because I think the magic is simply in what is the cap number. I mean, certainly we can make the cap high enough where you get people's attention, you get prospective employers' attention. They know that it is a number that no one would factor into as a cost of doing business. So I would disagree with you that caps can't work because of the reason you stated. You have any thoughts on that?
I mean, I'm against anything that takes a jury's right away to make a decision. I'm a big proponent of the Seventh Amendment and the Declaration of Independence that gave us the right to a jury trial. So any limits on juries' decision-making, I think, is inappropriate. I think in this set of circumstances in particular, you're dealing with intentional misconduct. And because discrimination is intentional misconduct and is 100% preventable, putting any kind of limit on it, any kind of number on it is just putting a price tag on it. And when you have an employer like Walmart who's making $300,000 in 37 seconds, at some point it's not going to be an incentive for them. So I think it's up to a jury to make that decision. These aren't the kind of runaway jury cases that you see in other kinds of.
But we haven't had those in Georgia.
Well, we have them in the
Right?
federal
We don't have
courts.
this cause of action in Georgia, right?
True. True. But I mean, in the federal courts and in the national system and in the nation, I mean, there are other we're one of 3 states without laws. There are plenty of other states that litigate these issues. And these aren't those kinds of verdicts that I think, you hear about in other areas that people are more concerned with. This is really more about what is it going to take to give people the accommodation they need to be able to continue to do their job.
Okay. One last comment on that, and it is, I understand the nature, and I agree with you. If you're truly talking about intentional conduct, then at times that needs to be punished. But I'm thinking of, if I understand the intent and how this litigation might unfold, you could wind up with a legitimate dispute and a disagreement over whether or not the accommodation was appropriate or not. And I don't think that falls into an intent category. The plaintiff might plead it, and lawyers might want to cast it that way. But if I understand how this might unfold, I can foresee circumstances where not every case really is going to accurately be described as an intent to do harm.
I can see where you're saying that,
Okay.
Anytime you're making an argument about what is and isn't reasonable minds can disagree.
Sure. Last thing on line 109, can you tell me, it says this is identifying the different kinds of damages that can be awarded. You've got compensation for lost wages, front pay for or reinstatement benefits, and then other remuneration before it goes to compensatory, punitives, and reasonable attorney's fees. What is contemplated about other remuneration as a form of damages that would be recognized by the statute?
Typically, it's medical expenses, or there's loss of your financial, like your credit reporting and your reputation. Things like that are typically what covered under.
Okay. Okay. Thank you. Thank you, Mr.
Sure. Senator Jones.
Thank you. On the 180 days, I'm just kind of processing it to some extent. First, on the 180 days with the EEOC, given the 2 years, does it actually kind of help persons kind of deal with the issue, negotiate it to some extent? Because a lot of times with those EEOC cases, something happens, the clock is running, and you immediately have to go ahead and go file because you're under that. So the 2 years may limit litigation to some extent. But also, is there any thought when you're given the 2 years that you're actually saying, you're almost kind of like giving a grace period to some extent with 9 months, because you're dealing with someone who is pregnant and then also may have a child, and you're almost saying, okay, we're going to give that period, and then the clock sort of starts to run from that standpoint. And I don't know if that goes into the thought process at all or not.
Most certainly. I think that's one of the most difficult parts of pregnancy discrimination, is the 180 days is going to overlap with the pregnancy. And so it's not just the 9 months, it is the time afterward that you're talking about. So this really is more like a 1-year statute of limitations as opposed to a full 2 years.
All right. Are there other questions from any other committee members? Were there anybody in the audience that had signed up and didn't get to weigh in the other day? Well, how about just stand up if you're in favor of the bill? All righty. You got 1, 2, 3, 4, 5, 6, 7, 8. All right. And 9, 10. All right. We got a man that's He got worried about his pregnancies. Okay, good. All right, y'all can have a seat. And likewise, anybody here that's in opposition to the bill, stand up. Okay, thank you. All right, if there are no further questions, what's the pleasure of the committee? Yeah.
I want to take the honor of being the only woman on this panel and the only one who's had a baby to make a motion to pass.
All right, we have a motion to pass. Is there a second? Yes, sir.
Had a baby, but I'm going to second this motion.
All right. Is there any discussion on the bill? Got discussion from Senator Setzler.
Yeah, I appreciate the sponsors, Mr. Chairman's consideration. I just, I want a bill that's a clean up or down vote. I know there's an effort, a multi-state effort to effectuate policy changes in this way, and we've worked hard to make sure we're protecting the most fragile members of our human community. I'd like to offer an amendment, Mr. Chairman, at the appropriate time. Are we in that posture?
I think we are in that posture. What's your proposed amendment?
I would like to offer as a friendly amendment, but it would say nothing in this chapter shall be construed to allow an abortion, and I can share it with council, that would otherwise be prohibited under Article 5, Chapter 12 of OCGA Title 16, which is the abortion code. So, again, nothing in the chapter shall be construed to allow an abortion that would otherwise be prohibited under Article 5, nor shall it allow for the funding of a lawful abortion by an employer pursuant to any provision in this chapter. So, this chapter couldn't require an employer to fund a early term out-of-state abortion, and nor would it overwrite our existing code where there are prohibitions under Article 5. So essentially, no requirement for funding and no change of existing law. That's the effect of the amendment. I can share this with council if he wants to reword this.
Would you want to put that on 38 and 39 in place of the language that we have there? Is that the?
I was actually thinking, Mr. Chairman, on 34 5B-8, which would be line after line 122. Right now it stands alone in that code section, the new code section. We would renumber. This chapter would be subsection A, it would add a subsection B, and we just add this in after that. And we'll share this with council.
Mike, is that where it would go? All right.
What line were you on again? I'm sorry, I didn't follow where you were.
I'm on page 6.
Okay.
Yes, sir. Line 122.
Okay.
At the end of that, we would renumber right now that 34.5B-8. It's a standalone text in the code section. We would label that current text subsection A, and then create a new subsection B below it, below line 122, and add that language in that I just shared with council. I can reread it if I need to.
Read it if you don't mind. Read it more. No,
Yes, sir.
I'm not
I would.
the chair right now, Mr. Chairman.
And if go right ahead, reread it. You got it.
And council's got, if he's, I would defer to his greater wisdom and certainly renumbering appropriately, but he would say subsection B, nothing in this chapter shall be construed to allow an abortion that would otherwise be prohibited under Article 5 of Chapter 12 of OCGA Title 16, nor shall it allow for the funding of a lawful abortion by an employer pursuant to any provision of this chapter. So nothing in this chapter could give rise to employer funding. So, hey, whether it's an accommodation, whether it's a negotiated circumstance for an adverse effect, I mean, I think there's a lot of ways one could backdoor their way into that. I want the public to know what they're getting with this, and I want the members to know what they're supporting it.
All right, I think it's clearly stated. Is there a second? Second from Senator Watson. What's the pleasure of the committee on the Setzler? You want to be heard on that, Senator Hatchett?
I do. Just with clarification here, this is a cause of action for retaliation, correct? Yes. So I want to pause on this amendment, or maybe we should see if it's going to pass or not first, but I don't think that this amendment does what you're intending for it to do.
Okay. Well, and it's a fair question. I think the concern is if you've got a circumstance where someone asserts, we're creating a statutory right through this, right? We're saying you have a right to equal treatment that men would have. That's something I think everybody in this panel supports. If the accommodation is, hey, we're trying to create a equal playing field, which is a worthy objective, if the way to level the playing field is to say, hey, this creates an opportunity. And by the way, let me just say a parent thing. I don't want to be having this conversation on it. This is not something I enjoy at all. I just want to make sure as we think about this, we're not creating a circumstance where we create this statutory duty, create this opportunity for someone to bring an action that they can then assert, hey, to effectuate this, I need to be given an opportunity as an accommodation or otherwise. I don't know that it's clear that you're allowing this, but I think that would certainly could be argued in the courts, and I know there are some courts that are very friendly to that. I do think it'd be very easy to say that as an accommodation, an employer could fund an out-of-state trip to take care of your pregnancy. You can come back. That I will pay for your accommodation rather than giving you a light duty work or whatever. It's a conversation I'm wanting to have. I don't necessarily need to formulate it as an amendment until the committee's comfortable with it. I don't want to lose an amendment. The committee doesn't.
You've already presented the amendment. It's been seconded. We're now discussing it. So you want to withdraw it?
I'm not going to withdraw it, Mr. Chairman. I do want there to be a comfort level of the committee members that this is not.
May I be heard, Mr. Chairman, on it?
Yes.
So logistically, I still think it needs to be under the definition of reasonable accommodation, because that's what the suits would be about if there was lawsuits. And that concern was raised to me by someone else, and everyone I talked to that read the language says no way that would be deemed a reasonable accommodation. But we still included it in the sub lines 38 and 39, because we're not trying to have, this is not the intention of this bill. We're not trying to make this bill a workaround with our current laws on abortion. And so to be clear, that's why we added that line there. It's just, I would think from a just drafting standpoint, it probably needs to be in that section if you want to add some additional language there. Do you have anything else you want to add on that?
I think, the definition of reasonable is always something that's only legal activity. So I think it's already covered under the bill the way it's there. I think that's a boot and suspenders by adding in this additional language on 38 and 39 that covers what your concern is. So I think that's already something that would not, as it is drafted and also reiterated, be a reasonable accommodation or something that an employer would be required to provide.
Mr. Chairman, I'm fine to submit to the thoughts of the committee. I just, I don't know that it could hurt. I'd love thoughts of committee members that there's a lot of experience on this panel.
Well, it's time for discussion. If anybody else has anything they want to add, now's your chance. Okay, all in favor of your amendment, raise your hand. I don't guess I get to vote as chairman. All opposed? There's 4 in favor.
Needs to vote.
Excuse me.
I think Senator Strickland needs to vote too.
Well, he had his chance. Did you want to vote on that amendment? Or
I'll vote for the amendment.
all right, so that's 5 in favor. All right, back to all opposed. 1, 2, 3, 4 opposed. The amendment passes. All right, amendment passes 5-4. Now, any further discussion on the underlying bill? What's that, Senator Hodges?
For the amendment.
I'm sorry, what?
You had me voting. I did.
Okay, you're against.
All right. You're against. So the amendment's a tie?
4-5.
4-5. So it didn't pass.
All right. 4 in favor or 5 in favor?
4 in favor.
All right.
Mr. Chairman,
Maybe we should just.
let me do this. I don't want to put our members in an awkward spot. If there's philosophical agreement that we don't want to allow this, but there's not belief that this amendment solves it, I will withdraw the amendment. I wanted to hear some of our peers. I don't want to put people in an awkward spot. I want to accomplish the goal, but I don't want to create chaos in the bill, Mr. Chairman.
You're not going to get unanimity on the committee whether it does or does not accomplish what you want.
I want thoughtful.
I can work, if you're going to withdraw the amendment, I can work with you when reviewing this. If we need to go with stronger language, this bill has a long ways to go through the process. So that we want the same thing, it sounds like. We're on the same page.
Sure, I will withdraw the amendment.
All right. Any further discussion on the underlying bill? I will add my 2 cents. I'm not comfortable going forward with this new state cause of action when there's so much confusion and consternation over it, and the federal law is so recent. I, as an employer, and I think many business people will get confused here with two different layers, federal and differing state laws on pregnancy discrimination. What do they do? How many days? Are there caps? What courts they go in? And so I'm just not comfortable at this point going forward with it. But it is only 4 before the committee. There's a motion due pass, and it's been second. Any further discussion of it? All right, all in favor of the bill, and I should say that's by committee substitute. That is LC 520-502S. Raise your hand if you favor the bill. You do the count for me. 6 in favor, all opposed? And I got 3 opposed. All right, it passes. What you got next?
Thank you.
I think you're on the next bill as well.
All right, let me see if I can shift gears. Thank you. Mr. Chairman, I'd like for Senator Jones, Manuel Jones, to join me up here as well.
All right. Come on
For
up,
Senate Bill
Senator.
371. Yeah, thank you.
What's the number of the bill? What's the number?
371.
All right, Senate Bill 371. It's in our folders. Daniel D. Pazziadli Jr.
Pazziadli. I've been practicing it.
Jr. Act.
Saying it right finally? Okay. Thank you, Mr. Chairman. Members of the committee, bring to you Senate Bill 371 along with my colleague from Henry County as well. We call it the Daniel D. Pazziadli Jr. Act, and he's actually with us. He's going to testify. I believe he's not to speak as well in this bill. He is a corporal with the Henry County Sheriff's Department. I'll tell you the quick story where this bill came from, and I'll turn it over to my colleague as well. July 16th of last year, there was a shooting inside of Hampton, quiet small town in Henry County that now Senator Jones represents. I used to have in my district, where multiple people were shot and killed. It was a scary day in Henry County. And that evening or later that day, multiple agencies found the person that was doing the shooting inside of Clayton County. And in that, Corporal Pazziadli was shot in the line of duty. And he was injured. Luckily, he was able to recover, but he's not able to work because of the injuries that he had. And he'll tell you more about that. After that happened, we both of us got a call from our sheriff, Henry County Sheriff, who's also here today, Reginald Scandrett, who reminded us of an issue he already knew about. And that's when an officer is injured in the line of duty, they fall under workers' comp like any other employee. And they only get 66% of their salary while they're trying to recover from their injuries. And our sheriff held a fundraiser raising money from the community to offset that deficit. And it was reminded us when he called us that the law should be different. First responders like peace officers that are hurt in a line of duty like this, while luckily it's rare, but in these circumstances, we should do more as a state to stand up for them. And what you see is when an officer loses their job because they can't work because they were injured fighting for us, trying to keep us safe, a big part of the salary for law enforcement officers or other jobs, they also work part-time. You also lose that as well. And you have a constant issue, especially today, with trying to recruit people to go into law enforcement. And it's one of the things that actually we learned together comes up when someone's thinking about whether they want to get in law enforcement, they have a family. They think about the what ifs, all things that could go wrong, the things we don't think about as elected officials or in our day jobs every day. They might have to think about that. What's going to happen if today's the day that I'm on the news and I'm injured in the line of duty as I run towards something the rest of us run from? And so this bill looks to provide a remedy under the state law. I want to commend Senator Jones, I guess I should say Senator from the 10th, because he will deny this, but this is his bill. He's the one that worked on this initially. He did a lot of the front work on this, and he brought it to me. And, of course, I was happy to help him with it. But he went with what we think is a simple way of handling this, and that is to not go in and change our workers' comp laws. But instead, as you see in Section 2, it says that if a Georgia peace officer suffers a catastrophic injury as defined already in the law in the line of duty, immediately engage with a criminal suspect or in the immediate pursuit thereof. So it's narrowly tailored to just one particular type of situation. That if they qualify for workers' comp law, then that the fact they qualify meet this standard gets turned over to DOAS, and we already have a state indemnification fund that already exists by law that they then are allowed to tap into to fill that gap, to get the rest of the percentage back, to get their full salary while they're recovering. The goal would be that as long as the workers' comp case is still active and they will still qualify to continue to get that backfill of money. I will tell you in full disclosure, when you put bills on the agenda, it allows for more conversations about the bill. I've had some good conversations with DOAS and also with our workers' comp board friends as well. And we may have some tweaks and may offer through the process if we can move this bill as it is to keep it going at this point, with some of the details about how the file gets handed over and how this is funded. But we don't think, I can't sit here and tell you what the fiscal note is, what the fiscal impact is, because I hope that nobody qualifies for this. But I can't tell you how many officers may qualify for it next year. Right now, we're not aware, unless someone corrects me, of any officer that would currently qualify for this. The officer it's named after is back at work again. The day he met with us to talk about this bill, we had our draft together. He was going back to work that next Friday. And so he's not going to benefit from this. But his goal was to make sure the next person hurt like him has their family covered. And for every single person that thinks about going to law enforcement, they know if they get in this situation, their family will be taken care of. And I appreciate our sheriff for having the fundraiser, and for all our people in law enforcement that come together, as we all do in a community, and stand behind people that are hurt in the line of duty. But we shouldn't have to just do that through raising money locally. I think, and this bill will accomplish the fact that the state should step up and pay that. And so that's what the bill does, and I'll be happy to turn it over to Senator Jones if you want to add something to this as well.
Thank you.
Before we do that, help me with what's the difference in a peace officer and a law enforcement officer? Your bill, the summary of it at least seems to distinguish.
Yeah, and so I'll let someone from law enforcement correct me, but it's defined by law. And so you have look on line 25, line 24 and 25, and you have someone that has to require the Georgia Peace Officer Standards and Training Act as contained in Chapter 8 of Title 35. And so I believe that is already defined by law.
So that's post-certified officers.
That's correct.
And so what's the difference between those? So they're already covered, right?
They are not. And so the state officer, and again, somebody correct me if I'm wrong, someone that works for the state already has a separate ability to be funded on this. But I need to back up a little bit. If you look at lines 19 through 23, it further defines. So it's an eligible peace officer who's employed on a full-time, part-time basis by the state or any municipality, county, or other political subdivision thereof. And so we do limit it down to someone that's post-certified that's working as an eligible peace officer locally.
So a peace officer has to be one that's post-certified.
Right.
Right. Okay. Senator Jones, good to have you with us.
Thank you, Mr. Chairman.
Hear your views.
And first, let me say thank you to my colleague from the 17th, the chairman of this committee, who saw fit to kind of work with me on pulling together this legislation before you. I feel very, very strongly that this is something the state of Georgia should have done a long, long time ago. This bill, as has already been stated, is narrowly tailored to only those individuals that are injured in the line of duty, either in pursuit of a suspect or engaged with a suspect. And as already been said, I think we all pray that we do not have any of our officers that are injured performing their duties. But for those officers that are injured, this legislation will provide additional income above and beyond what workers' comp would pay them. Of course, workers' comp has been stated is already at 66%. The whole thrust behind this bill is to use the other indemnification count, as my colleague has shared with you, the chairman has, to cover that other 34% of their compensation. And some may say, well, workers' comp is making an allowance for taxes. That's true. But as been stated, and as sure as those that are behind me, the men in blue and Officer Potlines, will share with us, just having a job is not enough for them, because as we know, our police officers and peace officers do a lot more than just work for one subdivision. They work in other occupations, and I believe he will testify about what it's like and what life is like for him and his family, and what happened after he sustained multiple injuries, by the way. And I will also add that I do believe, and I hope he will correct me, that he still has some shrapnel in his body from his injuries that he suffered. So this is working collaboratively with my colleague from the 17th. We share Henry County. And of course, our sheriff from Henry County is present, where Officer Potleali currently, and I do apologize for the mispronunciation of his name. It is difficult.
We've struggled with it.
It is, but an that
could have been Smith, or something
yeah,
simpler
would
for
have
us to
been
say.
much easier. But this legislation strikes an excellent balance for the state of Georgia and for those who serve us and risk their lives in protecting us. But when they do, I believe, Mr. Chairman, that we should not cause them to have to go out and scrape and people to donate funds to them, but they should be able to sustain themselves while they're recovering from those injuries. And this account under DRAS is an account that already exists. It's already funded by the legislature. And may I add, DRAS has stated that this account is rarely used. And I've learned from many of the peace officers present that some only thought it was only for death benefits, but that is certainly not the case. And I believe this is a good use of that particular account that we already have in place, working through existing laws and the existing process we already have with our workers' comp.
So this is essentially supplementing the workers' comp benefits that don't pay 100%, and you're going to pay officers 100% of their wages. Is there a cap? I mean, they could make $250,000 a year or $25,000. Does it matter? We're going to be paying the full rate.
There isn't a cap on what the police officer would make. Again, we narrowly tailor it so it only apply for a very few and hopefully none of our officers in our great state. But it only pays that difference, that 34%. From what workers' comp would pay, and that officer would still be under the guidelines of workers' comp. And when their workers' comp benefits would end, of course, this benefit would end as well.
Yeah, but there's no cap on the income. If they're captain and making $150,000 a year, then they're going to get $150,000 or the pro rata per week as long as they're disabled.
That is correct for those officers that are injured until they recover, Mr. Chair.
All right. Senator Setchler, you're recognized.
Thank you, Mr. Chairman. I'd like to thank the authors for the bill. I put this in perspective. In Cobb County, there's placards up, and I know Cobb pays more than some counties do for law enforcement officers, that looking for new officers for starting pay of $50,377 a year. That placard is just burned into my mind. That's about $5,000 less than a starting school teacher for the bachelor's degree. These are people that are not they're not doing it for money. I can't imagine being injured and being reduced to about $33,000 a year to raise a family after you're injured in that role, which is already modestly paid. So I appreciate the bill. And Mr. Chairman, appropriate time, I'd like to be recognized for a moment. Did you have a question?
I was recognizing you for a question. We've still got people testifying on this bill. Okay, we'll get to you then. We're going to remember you to make the motion when the time comes.
Now it's a question.
All right. All righty. Let's hear from Officer Podziadli. Have I got that right? Come on up. Daniel Podziadli, Henry County Sheriff's Deputy. Thank you for your service, and we're happy to hear you're back at work. That's great. Okay.
I'm glad to be back. Mr. Chairman, I thank you for your time. Committee, likewise. Just to give you a little backstory or a little bit about me, I've been in law enforcement now for 30 years. And yes, somebody said it on the panel just a moment ago, I don't do it for the money. I do it because it is a passion, it is a love, and I love the people that serve in it. Prior to that, I also served 5 years in the Army, military police, so I've been policing now for 35 years, and it's pretty much all I know. I would like to take a second and thank Senator Strickland and Senator Jones for your wisdom for your passion in getting this pushed to where we need it to be. And also Sheriff Scandrett, you and your team, we are internally grateful. With that being said, July 15th and 16th of 2023, last year, we had a mass shooting in Hampton, Georgia. To summarize this, we had an individual who was suffering from PTSD, was off his meds, things of that nature, and he killed 4 people on the 15th of July. He tried to kill a 5th person that day, which was his mother. But fortunately, she was able to talk him down, and she was able to escape and actually go to a local library and call 911. With that being said, law enforcement got involved at that point. Of course, Sheriff Scandrett rallied the troops, and we rushed to Hampton to provide whatever help we could. On the very next day, July 16th, I was told to come in for duty at 12 noon. So I expected to kind of be on duty through the night. And my goal, like all of our goal, was to get out there and find this person. Well, I have a knack for having bad elements find me. It's been that way my whole career, and anybody that has served with me will tell you that. I am a magnet for people who do wrong. This was a case no different. On this particular day, I rushed to Clayton-Henry County border, where we had some intelligence that where the suspect was. So when I got there, I spotted the suspect. And from the moment I spotted him to the time that I got shot was less than a minute. Myself and another deputy from Clayton County, Sergeant L. Davis, we were essentially ambushed. We could not return fire. We didn't know where the suspect was. It was just bullets were coming our direction, and we were zigging and zagging, trying to seek some cover and concealment. And as I made my way to a wood line to get that cover and concealment is when I was shot in the back. I was shot by a 9mm. The bullet missed my spine less than an inch. And I thought it was just a back wound. However, I found out after surgery that the bullet, when it traveled through, it fractured my pelvis, and then the bullet at that point fragmented. And I had shrapnel, someone stated, I think Senator Strickland, I have shrapnel embedded in my hip, if you will, a lot of it, which they cannot remove. And then the other half of the bullet went to the left. Well, when it went to the left, I didn't know it at the time, but it hit my colon in 2 different spots. So I had near fatal injury. They rushed me into surgery, and I got to give kudos to Grady and my surgeon. She's awesome. She put me back together. But with all that being said, my recovery was about 6 to 7 months. I am still technically in recovery, if you will, because I'll never truly be the same again. But with that being said, when I went under workers' compensation, which I've had many officers under my tutelage have to go under workers' compensation, I lost basically 20 to 30% of my pay. And all I could think about sitting in the hospital trying to recover was how am I going to pay the bills and keep a roof over my head. My wife works for Emory. She has had to take, she took off of work for at least a month, maybe a month and a half, just to take care of me because I was totally incapable of doing so. So technically, not only did we lose my income, or part of it, but we also lost her income. So we had no really full paychecks coming in anywhere. Not to mention that I also lost built-in overtime because I'm a canine handler, and that requires extra things after duty. So I lost that pay, and then I lost any part-time work that I would do, you know, during the course of the week or on the weekends. So there was a lot of money lost. And when the sheriff came to me in the hospital, he was there first thing by my bedside. And as I've said before, we laughed, we cried, and we prayed together. He had asked me what he can do for me. And I simply told him, I said, well, I will agree to a fundraiser, because that was the plan initially. I said, however, I want to make this bigger than me. I've been in this profession for decades, and I just wanted to leave something behind that I could pay it forward and make sure that the next officer gets taken care of right out the gate. Because I assure you, at the rate we're going in 2024, this is going to happen again, and it's going to happen sometime soon. And again, none of us do this for the money. We do it because we love our communities, we enjoy what we do, and we do it for all of you. And all we are asking is to be taken care of when we are critically wounded in the line of duty. And I don't think that's really much to ask, considering, you know, what we do and the low salaries to begin with.
Great.
So that's kind of my story.
That's
and,
great.
Hopefully we can get something moving.
You are a true hero. We're lucky to have you. Henry County's lucky, and your sheriff is here.
Yes, he is.
And he is next on our list, so I'm going to call him up at this time. Sheriff Brown. Kendrick Brown.
Brown's coming next.
Oh, I'm sorry. Kendrick, I skipped over, I guess.
Mr.
So
Chairman.
good to have you here. Tell us.
Thank you, sir. I certainly appreciate
All right.
that, and distinguished members of this board. This is an honor to sit before you, but certainly to raise levels of consciousness with respect to the challenges that our officers face when no one is looking, particularly when they're struggling after injuries that Mr. Ponziali experienced. As my wife would put this, I think that this bill should target an officer's me time, their mental and emotional awareness. And that is challenged. I watch this individual and so many others in my 33 years of doing this suffer. And so I think that this bill should target more specifically to all of the officers, and I can speak confidently for my colleagues, the 159 sheriffs that we have in this great state that we live in. How can we help you suffer less? That's the bottom line for this bill. And we talk about a lot about supporting public safety and law enforcement entities. I think this is certainly a time frame to do that, to come together, raise levels of consciousness, and to calm the waters with respect to what our officers and our men and women think about when they don this uniform each and every day to ensure that we can sleep well at night.
Thank you. Y'all got our back, and we need to have yours. Any questions? All right, I did have one other. Was it Sheriff Brown also, or okay? Come on up.
One of the other sheriffs in the district.
Yeah, that voice reminds me so much of James Earl Jones. I would hate to be arrested by you. I guarantee, I'd say yes, sir. Sheriff Brown, thank you.
Mr. Chairman, I am Ezel Brown. I'm the sheriff of Newton County, and I'm also the president of the Georgia Sheriff's Association. First of all, thanks to this body here today for your hard work and your steadfast leadership. It's been said so eloquent by, and I'm not going to butcher the name, Corporal here, what we faced, and also Sheriff Levitt. But in the meantime, I'll pause, and I'd like to thank Senator Jones and also Senator Strickland for taking up the mantle and passing it on to you all and each and every last one of you here. I've spent 50 years plus in law enforcement, so I have a number of stories that I could tell you. But at this moment here, I want to stop and just say I thank you again for showing your support for the men and women of the great state of Georgia. We appreciate you, and I know each and every last one of the sheriffs, executives throughout the state of Georgia appreciate you as well. Again, I support this bill, and I certainly hope that no one in the state of Georgia will ever need this compensation. Again, thank you so much. God bless you.
Thank you, Sheriff. I recognize Senator Setzler for a motion.
Mr. Chairman, I'd like to make a motion that do pass.
All right.
SB 371 LC 460739.
All right. And I'm going to recognize our pro tem.
Thank you, Mr. Chairman. I'd like to second the motion.
All right.
Motion do pass.
Senator Jones, how about a little bipartisan love? Would you like to give us a third?
Yes.
There we go. We got it all. All right, is there any discussion? Very good bill. All right, all in favor, raise your hand. Let's see them all. Any opposed? We have a unanimous vote. Thank you, Deputy. right, I'm going to put Senator Strickland back to work. Is Senator Robertson here? You got, all right, come on up. You'll go. 7:44.
All right. I'll say we don't have to follow that, but I guess you'll have to try, Senator Robertson.
No, sir, I do appreciate Senator Jones and the chairman's work on that. That's a great piece of legislation and long overdue. And I know the men and women of law enforcement, which tomorrow is Law Enforcement Appreciation Day here at the Capitol, the men and women that show up for that will be very happy to know that this committee is standing with them.
Well, thank you, Senator. We're going back on the agenda, Senate Bill 415, working off of LC 394092. The floor is yours.
Yes, sir. Thank you. Mr. Chairman, I know that the time is late, so I will try to be as concise as possible. As we police in today's world, it's clear to everybody outside of this building and inside of this building that we continue to struggle with bringing men and women who are willing to come in and do the job. A lot of times it's for the pay, a lot of times it's for the lack of passion, and sometimes it's because they just really don't want to do it. It bounces around between a profession and vocation depending on where you go, but there's a lot of work involved. So what we have to do to keep our community safe is we have to start leveraging what technology's out there. There was a science fiction writer many, many years ago. Some of you may know his name was Philip Dick, and he wrote a little story called Minority Report. A movie came out about it. Tom Cruise was in it, and he was talking about the technology used in the future to police the communities. And I promise you, when Philip wrote this story, it was long before Tom Cruise and many on this committee were even around. But technology has always been seen as the future in most of the things we do, and law enforcement cannot be left behind in that. Currently in the state of Georgia, we have about 10,627,000 vehicle registrations. Of that, every year the Department of Revenue sends out over 1 million insurance notifications letting drivers know that they do not have insurance here in the state of Georgia. Out of that 1 million that get those letters, approximately 559,000 respond back with either evidence that they have insurance or some other reason as to why they're no longer required to have insurance. So that is about a 56% clearance rate of individuals found to not have insurance that correct the problem. So what that leaves, if my Harris County math is right, is 44% of those letters do not come back. We take that number and slice it in half and give the benefits of the doubt that maybe several of those vehicles or half of those were either sold or no longer operational. And so what that leaves is around 200,000 vehicles operating on the streets and highways here in Georgia without any insurance. And if you will, I'll use the term registration, because we all know that you can't have a tag without insurance and you can't have insurance without a tag. So what this legislation does is it allows any law enforcement agency here in the state of Georgia that chooses to, and I will say that we have reached out to GMA and ACCG. They are both supportive of this because it offers them another tool should they choose to use it. And what this technology does is it's placed in a marked law enforcement vehicle that travels up and down the streets day in, day out, doing the job. And should it come across a vehicle that the DOR records show that has expired insurance or expired registration, the officer has two options. He or she can, they can engage their emergency lights, they can fall in behind the vehicle, and then do a traffic stop. I don't think I have to remind anyone on this committee how dangerous that can be. I'm not just talking about pulling a vehicle over in the middle of the night, maybe somebody you don't know, and get out and getting engaged with them over something that they know is going to cost them some money, but also just the fact that the officer gets out, stands on the side of the road, stays there for quite a while, and writes citations after all the checks come back in. What this legislation would do, what this technology would do, would give the agency the option to provide the officer with the technology that he or she could strike a button on the laptop inside their vehicle, automatically, based on the information received DOR, send that individual a civil citation through the mail. So if you have an officer that's out on patrol, if you have an officer that's engaged in going from a call to call, and he or she come across an individual operating a vehicle that should be registered and insured in Georgia that is not registered and insured in Georgia, then that officer has the opportunity to send that individual a citation while continuing on to whatever call they're on. And I think it's a very smart piece of technology. Again, there are no mandates in there that requires that any agency purchase this technology. But I think with the issues that we have with the hiring and other things, I think it's necessary. Now, under this building over the last few weeks, there's always conversation about technology and law enforcement. There's individuals that don't like it. The primary excuse I hear by the individuals that don't like it is because a friend or relative of theirs got a ticket in the mail. Well, I'm going to tell you, I've written a lot of citations, but a few weeks ago, my wife got a civil citation in the mail. And the plan in the Robertson house is if you get a citation, you pay it. And that's exactly what happens. And so I feel this is an efficient way to offer some help to public safety, and also a smart way to make sure that we have more insured drivers on the roads as we move up and down doing our daily things and as our family does. If you read through the legislation, which I know it's a little voluminous, but if you come over on line 56, it identifies what the automated recognition technology is. It's a system which converts images from video capture device into computer-readable data, which is compared to information relating to motor vehicle registrations and insurance maintained by the Department of Revenue. On line 60, it identifies the owners as it's the registrant of the motor vehicle, except that such terms shall not include a motor vehicle rental company when the motor vehicle registered by such company is being operated by another person under a rental agreement with such company. The good thing about that is many times rental vehicles have two levels of insurance, because a lot of times the driver of the vehicle is insured, but they tend to purchase the additional insurance just in case, because that can be very expensive. On line 69, video capture device, a camera or group of cameras installed upon a motor vehicle marked in accordance with code section 4891. Me personally, I'm not a fan of ghosted law enforcement vehicles. I don't think we're out there to sneak up on anybody when we're on patrol. What we're out there to do is let citizens see us out there doing our job and let them know that we're there if they need us. I think unmarked vehicles are reserved for special operations within law enforcement, and personally, I think anybody that's out there traveling around and enforcing traffic laws especially, or attempting to keep the peace, should be very visible in the community. Line 73 says the owner of a motor vehicle operated on the highways of this state at a time when the registration of such vehicle is expired, suspended, canceled, or revoked shall be liable for a civil monetary penalty which such operation is evidenced by stored images and such operation was not otherwise authorized by law. The amount of such civil monetary penalty shall be $100 when a motor vehicle has been operated which with an expired registration, and $200 when a motor vehicle has been operated with a suspended, canceled, or revoked registration. I think the advantage there, and we've had these conversations throughout my time up here in the Senate, is there's a lot of these citations that do not require an individual to be detained, that do not require an individual to be jailed, if you will, where we can take care of this more on an administrative side, lessen the police-citizen contact, while at the same time making sure that we're not filling our jails or temporary detention centers with individuals for infractions such as failing to maintain insurance or failing to keep their vehicle registered. On line 81, talks about the owner of a motor vehicle operated on the highways of this state without the minimum motor vehicle liability insurance covered required under Chapter 34 of Title 33 shall be liable for a civil monetary penalty which such operation is evidenced by stored images and such operation was not otherwise authorized by law. The amount of such civil monetary penalty shall be $200. I think the attorneys on this committee that have ever dealt with traffic court and dealt with the add-on fees and others will attest to that these fines are much lower than they would be if the officer pulled them over, made contact with the individual and wrote them a uniform traffic citation. Doing that, when you get to court, there's the add-ons that have been placed on by the General Assembly that go toward everything. I don't want to say under the sun, but pretty close to it. And a lot of times I attended court with a niece a few months back, and the judge continued to have to explain to everybody why the fine he gave from the bench got much greater when they got over to the clerk's window to pay the fine because the add-ons were not understood. On line 87, the law enforcement agency authorized to enforce the traffic laws of this state or agent thereof shall send by first-class mail addressed to the owner of the motor vehicle operated in violation of Code Section 41-252 or 40-1-253 not later than 10 days after obtaining the name, address of such owner from the Department of Revenue and following. The bill also goes into if the individual ignores it, with the second citation goes out, and it also briefly discusses what happened if the individual continues to ignore the citation. There are opportunities, should the municipalities or whatever decide to use it, to take up some kind of contract with a collection agency or something like that if they so choose. But in most of these cases, what we realize is with this technology out there, any individual that continues to drive without the proper registration and insurance on a vehicle, they're going to be captured either prior to an accident or at one. On 108, information advising the owner of the motor vehicle of the manner in which liability as alleged in the citation may be contested, which shall include an assigned hearing date to contest liability that shall be no later than 90 days from the date of issuance of the citation. Everybody that would receive one of these citations would have the opportunity to due process and to challenge it. That due process includes showing proof of insurance at the time and that there was some technical issue related to that, or also information that shows that since receiving the citation, they have went out and made the corrections. And what we've discovered in the process with writing uniform citations is that's what many, many people, well above 95% of them do. Once they're cited, they will go out and get the insurance. On line 119, liability under this article shall be determined based on a preponderance of the evidence. Prima facie evidence that the motor vehicle described in the citation issued pursuant to this article was operated in violation of the aforementioned code sections I said before, together with proof that the defendant was at the time of such violation the registered owner of the motor vehicle, shall permit the tier of the fact to infer that such owner of the motor vehicle was the operator or authorized to use the motor vehicle at the time of the alleged violation. And again, a certified may be rebutted with a certified copy of a police report showing that the motor vehicle had been reported to the police as stolen prior to the time of the alleged violation, proof that the motor vehicle had proper insurance or registration at the time the citation was issued, or proof that a citation was issued in violation of the requirements of this article. So anytime a citation is issued based on failure of the technology, which that would be with the contract with whomever they choose to use this kind of equipment or lease this kind of equipment from, as long as they adhere to all of the rules there, I think the citation would be good. But if anything fell out, I think it would give them the opportunity to challenge the citation. And then as you read through the bill, it goes on through what I'd mentioned before about the subsequent notifications of the citations that would be given. Over on line 195 is a violation for which a civil monetary penalty is imposed pursuant to this article shall not be considered a moving traffic violation for the purpose of points assessment under the code section 40-5-57. Our primary goal is to get people insured and make sure these vehicles are registered. It is not to punish anyone.
All right, Mr. Chairman, Mr. Whip.
Yes, sir.
We have questions from the committee. Senator Cowsert.
All right, how do you call this due process when the burden of proof is reduced to a preponderance of the evidence instead of beyond a reasonable doubt? When the burden shifts to the defendant in the case once the officer issues this civil citation, when the fine is the same it would be as it's a criminal, but you're only notified of it by mail instead of receiving a citation, and if you've moved, you may not even know you have this civil penalty. I mean, all the punishment's the same, and this is for about as a small of an infraction as you can find. It's not even a moving violation. You failed to renew your tag, and all the money goes to law enforcement on page 189. The money's collected and remitted to the law enforcement agency or government body there pursuant to this article shall only be used by such law enforcement agency or government body to fund local law enforcement or public safety initiatives. I mean, this is a shakedown. Why wouldn't police light up every car that they could find? Because they don't have to stop them. They send them a notation and they keep the money.
Mr. Chairman, they don't light anybody up. The fact that the individual is driving a vehicle on the highway in Georgia that is a violation of Georgia law, that's what initiates the technology.
But they send it to them. All they have to do is send out the notification,
yes, sir,
rather than even stopping. And how do you even know that the owner of who's driving the vehicle?
And that information is what I read before. But in these fines are lesser than a uniform traffic citation.
Well, they're the same as you struck through the code section. The penalty for driving with expired registration is $100, and your civil penalty
yes,
is
sir,
$100.
and they're not the add-ons.
So that's why they're less, because they don't have the add-ons.
And if you do the add-ons, we're talking about you take a $100 fine in recorder's court or traffic court. You do the add-ons, you're looking at just a little south of just a little north of $200. And what we're doing is the vast majority of these individuals out here operating are not out here intentionally trying to avoid the law. A lot of times they don't realize it's expired and all the other things that come along with busy life. But this is absolutely not a shakedown. If it's a shakedown, then officers could go out there and pull over every vehicle possible and look for mechanical infractions all day long. And they could write citations all day long. But what we don't have is we don't operate law enforcement in that way in this state.
Well, at least that way they would know that the violator was who was operating the vehicle, because they would be able to identify them and get their driver's license instead of just taking a picture. And this is just like the speed cameras, the red light cameras, the school zone deals that we've got. I mean, we've got letters in our file from Recor, who's the vendor that's going to benefit from this.
I don't
one
know
of them that's who's pushing these, law enforcement, because they keep the money, and the companies that get paid for the machinery for taking the pictures.
Well, the F-150 I drive that's in my name, I'm responsible for the tag. I'm responsible for the insurance, not whoever I loan my vehicle to. If I loan my vehicle to my wife's little brother and he's operating it, he's operating a vehicle that's in violation because I have failed as the vehicle owner to register that vehicle and to make sure I had proper insurance on the vehicle. And that's where I feel with it. Now, I don't know how many vendors there are out there. This is one of those things where I assume the company you just said, they would have to go out there and compete against everybody else that offers the same technology.
Are there others that offer it? Do you know?
Chairman Cowsert, this technology is not unique to one particular company. There's companies that offer this along with other stacked technologies that do the other things you're talking about, that not only look at registration. The unique part about this is tied into DOR, but there's all these other types of technologies that are currently in vehicles. If you see a patrol car driving down the road, you notice those little buttons on the trunk of the vehicle with the antennas. That is all technology inside that vehicle, which is why when somebody brought a vehicle up or a bill up dealing with arson of a law enforcement vehicle, the cost was so high, because the package inside that vehicle usually costs as much, if not more, than the vehicle itself. But I appreciate any advice you have, but I would hope that you know me well enough that I'm never going to promote anything that's a shakedown when it comes to law enforcement. But thank you for keeping me on point, and thank you for always making me enjoy that smell of napalm in the morning.
Senator Watson.
Thank you, Chairman. Mr. Whip, the real reason we're doing this is to try to reduce the number of people on the road who are uninsured motorists, right? I mean, that's the logic behind this, and that's why we have the fines. The technology makes it easier to do this, and this will probably strongly discourage people to be uninsured. If this becomes widespread technology, then the revenue should be high initially, but I would think after a while people will sort of get the idea that it's probably not a good idea to be uninsured. And one last point. Yes, sir. I mean, workforce is an issue, and whether it's in law enforcement or healthcare. I mean, to me, this technology drives what we're actually trying to do.
Yes. Isn't it true? It is true, isn't it, Mr. Whip?
It is.
Senator Setzler.
It is true, Mr. Chairman.
Thank you to the Majority Whip. Thank you for being here today and putting up with this committee. Great questions. I have a couple more, though. You and I have talked before about this idea of policing for profit. I know that's not something that you take lightly, but I mean, I would ask parenthetically, would you be open to, after the cost of service is paid for, certainly the contractor run this costs money, rather than going to the local law enforcement agency, would you be comfortable with the dollars going to trauma care, to fund trauma care for the state? So local law enforcement agencies would be doing this as a means to enforce compliance, but not to create this perverse incentive to do this as a revenue generator for the agency.
Chairman Setzler, I don't care where the money goes. I don't care if it goes into the general fund, because public safety issues are funded out of general funds.
Yeah.
It's just, there's, people have reached out to me and talked about putting it in this retirement fund. That, this, to Chairman Watson's point, if it were just about generating revenue, then we would go out and pull them over and write it, because there's much more revenue coming in, and a portion of that add-on fee goes to the Georgia Public Safety Training Center, the State Police Academy. Well, we're sacrificing that by this because it's more important to make our roads safer. But you're absolutely right, and I'm so adverse to revenue-based policing is today in a bill I reduced the number from 35% of an overall budget that can be generated from this type of stuff down to 30%, which I think is going to expose a lot of the speed traps and ne'er-do-wells in our state that sadly still exist today.
Yes, sir.
So I'm adamantly opposed to revenue-based policing.
So Mr. Chairman, I think trauma care funding something we're looking to provide. I wasn't sure if you'd be open to that. Secondly, I would say, if I could, Mr. Chairman, I see a big difference between the fine for having a expired tag versus the issue of the substantive issue of lack of insurance. Right now, the cost for a late tag is $10. I know that because I've paid it in the last 2 years. We were in session, and I went by, I think, 5 days after my birthday during sessional 2 years ago, and I paid a $10 fine. I don't know why we're paying $100 for a late tag when the current cost is way less than that.
My wife received that citation a year ago, and to be perfectly clear, I was driving her vehicle when it was pulled over, but she's the owner of the vehicle, and the citation she got 2 days after her birthday was much, much more than $10. Yeah. It's an expired tag. It's not a forgetting to get your decal. We've had kiosk put in grocery stores in my district to help people do this, but it's not $10 in those cases. Maybe your situation was unusual.
Maybe Cobb County has a grace period, but it wasn't long
You got
after.
the
but it-
discount. Yeah. That's why we don't tell personal stories on the record, Senators.
There we go.
Well, it may have started out with, do you know who I
Dr.
am?
Watson, did you have something else?
So I do think the non-insurance piece is a real public safety. I think it's a real issue in our state. I think that's something we want to remedy. Did you say in the earlier questioning from Senator Calzert, you talked about remedying, you go to court and prove that you had insurance on the date. Did you say that if you get, from the date of the citation to the date you show up in court, if you get insurance subsequently, can you show up and say, well, I didn't have it on the day, but I've gotten it since, here it is, and you get off as a result
That's
of
the
that?
discretion of the judge, but in many cases, the judges do reduce or dismiss, because most judges, again, aren't there to generate revenue. They're there to try to make people, and look, this is, and I think you described it well, this is a minor infraction, traffic infraction. And so, the courts aren't there to punish people, but when you go into Recorder's Court in Muskogee County, I mean, the add-on fees are tough. And a lot of people that are standing there in court that don't have friends to call, it's, they're setting up payment plans and things of that nature.
Dr. Watts.
Yeah, I mean, I would like to second the motion for it to go, after the expenses are paid, to go to the Trauma Care Network.
Now is not the time.
Okay.
Thank you.
I stand.
Any other questions from the committee? Okay, we have one of the persons out to speak on the bill, Amanda Couch with the District Attorney's Council, Oklahoma. All right, welcome.
Long day for you guys. Good
Just a
evening,
little.
everyone. Thank you for having me. My name is Amanda Couch. I am with the District Attorney's Council in Oklahoma. We have a program called the Uninsured Vehicle Enforcement Diversion Program. We're the first and only state in the nation that has one of these ALPR license plate reading programs that we use in order to enforce our insurance compliance. I am here today to tell you some of the good things about it and to talk to you about how we do things, and I would be very excited to have another me. I've been all alone for the last 5 years doing this. It'd be great if another state joined in. Missouri has enacted some legislation. Texas has considered it, and here I am in Georgia to see what I can do. So back in 2015, we were actually considered to be, either us or Florida, the worst as far as uninsured. It was somewhere in the neighborhood of 25%. 1 in 4 Oklahoma drivers were uninsured. And obviously the District Attorney's Council, the insurance department, everyone did not care for that statistic at all. They got together and they enacted the legislation that brought my program into place. I'm not going to get, I'm not going to get too far into the weeds as to how it works, but we do have 77 stationary cameras. We don't put them on police vehicles. We have stationary cameras across the state. They are in every single judicial district, and then also additional ones in our metro areas. When we started the program, we call it a hot list. Essentially, it's personally registered vehicles that do not have personal lines of insurance. Had north of 315,000 people on it. As of this morning, and I checked on the plane, we're down to 195,180. It's nearly a 40% reduction over 5 years. Additionally, of all of the notices that we send out, which is several thousand a month, 72 to 73% of them end up having a positive outcome. Not everyone enrolls in the program, but all of those people end up getting insurance anyway. I would like to talk a little bit to the officer safety provisions that Senator Robertson brought up. This is something that keeps our officers from having to deal with anyone. It keeps law enforcement interactions to a minimum. It also allows for a concentrated and singular place where the paperwork is processed. I was listening to him read some of the parts of the bill, and I was listening to all the different things that might have to happen with follow-up citations. We do pre-charging diversion. So these are going out as essentially notices saying, hey, we know you don't have insurance. You need to contact us. You can enroll in a diversion program, or we could send you on for prosecution. To date, we've only had to send one person on to prosecution who just blatantly refused to work with us at all, and that person no longer has a car. He takes a bike everywhere he goes. So our fine in Oklahoma for not having insurance is $250, and that is not inclusive of court costs, fines, fees, the things that Senator Robertson was talking about, the add-ons. The fee to enroll in our diversion program is $190, and that is essentially the only thing you have to do. Get your insurance, $190, because we know we'll be watching you with our cameras, and we will catch you if you go back on your deal. So I am ready to take questions, and obviously I'm very excited to help you.
Senator Cowsard.
I'm fascinated that your employer would let you take time off to travel to Georgia to advocate for a bill in this state. Why do you care? Why are you here worrying about people's expired licenses and registrations in the state of Georgia?
So we don't do anything with the expired registrations in Oklahoma. This is simply for uninsurance, but it behooves all of us, and especially those states around us, to bring down the uninsured rate everywhere. We believe that that brings down the rates for our citizens. It would bring down the rates for your citizens as far as what they're paying for insurance. And so it's an important project. We are proud of how successful it has been. And like I said, I'm from Missouri originally, and when my home state decided to look into this, I went there. And when Texas, where my sister lives, wanted to do it, I went there. I think it's important. That's why I'm here.
So right now, Oklahoma's the only state out of 50 that has this program?
Correct. Missouri enacted its legislation but hasn't launched it yet.
Okay. Thank you.
Mm-hmm.
Who's your vendor there? And
Our vendor is actually RECOR.
So RECOR pushes the bills in these states?
We didn't start with RECOR. We had a different vendor, so that we ended up leaving for creative differences. And so we had nothing. RECOR did not have a presence in Oklahoma when we launched our program in 2018.
Are you compensated by RECOR or any other vendor for your efforts in spreading the gospel here?
Absolutely not. I am here because I believe in the program, and I would be here if it were RECOR or Flock or GATSO or anybody.
All right.
Senator Jones.
Thank you, Mr. Chair. I have a question for you, young lady. Also for the author, a couple of questions. I was interested in the pretrial that you mentioned and how that works. And then number two, on line 148 and 149, I just had a question about where it says about a subsequent citation should not be issued for the same offense. Was there any contemplation in actually increasing that 30 days to maybe 60 days, 148 and 149? And then second part of the question, though, is page 7.
Yes, sir, I'm on page 7.
Okay.
On 48 and 49, what that was is if the individual got the citation, that they wouldn't get picked up again by the device prior to curing the first citation. In other words, someone's driving around, insurance expired and all this, so they get hit, a citation is being mailed to them, and then the next day they're driving through the same area and they get hit again. So in other words, it wouldn't just continue. It would wait to give them the opportunity for the first citation, because Senator Jones, you have a unique experience where you understand sometimes if you have a uniform citation, you have the yellow sheet. So if you get pulled over the next day and the officer says your tag's expired, and you can show it and say, yes, sir, I got stopped for it yesterday. I'm in the process of rectifying it, and they'll let you go.
Right. I was just asking, was there any contemplation of actually extending that time? Give them 60 days instead of 30 days, maybe to rectify their situation.
I would be comfortable with that.
And then my other question along the same lines is, let's say they're hit with the camera.
Yes, sir.
But then they have a broken taillight or something, and the deputy then pulls them over. He's going to have something to show that they had that prior ticket, to where he's then going to ignore giving them the ticket for the registration or the insurance. See, because he now can pull them over for the tag. He's going to see for the lights, right, the broken light. He's going to pull them over. It's still going to come through that they have expired registration, but now they've been hit, so he has to ignore that and not write that ticket.
What he ignores it, not sends the civil.
Right.
He can. And that's his or her option. What he can do is get out then and write a citation as he would now. But he would make the decision whether to hit the civil. And I think in some of these cases, what we're trying to do, if he or she are in the process between calls, unless it's the kind of day where he or she feels the need to take the time to do mechanical defects, then I would think that if he wanted to hit the button and send the civil citation, that he would forego the broken tail light at that time.
I had one other, if I can, Mr. Chair. So on line 172 to 175, just on page 8.
Yes, sir.
This would preclude us from doing any stationary cameras. Is that correct?
My legislation does not contain anything about
Right.
stationary cameras, yes, sir. And I met my friend here from Oklahoma a little while ago. We haven't had a chance to have a conversation. Somebody came to my office and talked to me about the program in Oklahoma. Haven't had a chance to take a deep dive. They advised me that they would be here to testify on what programs they were running out there. I have some concern about stationary cameras for this particular violation because, for lack of a better term, I have some serious concerns about hunting over a baited field sometimes. And, a lot of times you condition people when they know where there's a stationary camera, they're not going to go that way. So, but she has experience in the system. I do not.
Can you tell us about the pretrial that you mentioned?
Sure. So our program is pre-charging diversion. It's even before pre-trial. And so there's no criminal citation issued at first. What we're sending is a notice, and we're very careful to tell people it's not a ticket, it's not a citation, it's a notice letting you know that we believe, based on state records, that you don't have insurance. And the remedy for that, and here's all of the evidence we have, and we are choosing not to prosecute you in exchange in a diversionary path. You will get insurance. You will give us the fee. We will watch you for 2 years, we really watch everybody always, because it's always a crime not to have insurance. But that is the agreement that you're making with the state of Oklahoma, that in exchange for not being prosecuted, you will keep the insurance and pay the $190 fee.
Any other questions from the committee? All right, no one else has signed up to speak on the bill. What's the pleasure of the committee? Do we have a motion to pass or no action from the committee? We have a motion to pass from Senator Watson. Is there a second? We have a second from Senator Hatchett. Reluctant. Have any amendments? Senator Setzler.
Mr. Chairman, I'd like to direct everybody to starting on 188. And I'm going to making these as we go. I'm looking to strike the language on 190. I'll read the sentence. The money collected and remitted to a law enforcement agency or governing body this article shall be used. I'm going to strike by such law enforcement agency or governing body. I'm looking for language if there's other things that are going on. I've not just found this code section to cover direct costs of technology, and with all remaining funds to we need language to the trauma care. I don't know what the trauma care fund is. Trust fund. I'm digging for that. I don't have it. I just found this section now, so maybe.
I think Ledge Council.
Mr. Walker.
In code, the organization or the fund is the Trauma Care Network Trust Fund.
I thought so, yeah.
And Mr. Chairman, I'm not really able to elaborate on it, but my concern with where I think the amendment might be going is this would be earmarking of funds to go to a particular fund. I don't know that that's as straightforward an amendment as might be contemplated. And
when we did super speeder, I know we're supposedly designating that. I do think that we passed constitutional amendment a couple years ago, didn't we? That under certain conditions we can designate funds. And what are there limitations to that?
There are limitations, and there's also quite a few specific provisions that have to be included in the legislation in order for it to even have the chance of passing constitutional muster. And as I say, I'm not really prepared to elaborate because this doesn't come up an awful lot, but there's a cap. 1% of a certain amount is any earmarks that get above 1% of a certain amount are not allowable, and so the provision can't survive. It requires a 2/3 vote. There's just a lot of kind of procedural hurdles to get through to do an earmark in a designated fund. I don't want to throw sand in this operation, but that this may be subject to that, and I'm not really prepared to go.
I would be fine to say that the funds, above the cost of technology, implementing technology, we go to the state general fund, and then below it, it is the intent of the General Assembly that such funds be used, which I know is not binding, but we do create a language in there that says that. I am very sensitive to policing for profit and creating incentives. I mean, it's to the author and members. I have serious concerns about cameras enforcing speeding anyway. For the cost of a relatively low-cost camera, we could have cameras on every road. We could enforce absolute compliance of speeding on every major roadway in our state. We don't do that because we believe there's this sort of sense of propriety. I think this is working towards a good end, but what I don't want to do is create a circumstance where we create a financial incentive to agencies to do this first as a revenue source, because this will be a phenomenal revenue source.
Are you offering an amendment still then?
Yes, Mr. Chairman. I want to do amendments well. I don't want to do things willy-nilly, but I have a fundamental concern of this going to local governments.
So do you want the amendment to be it goes to the state general fund? Is that your amendment?
Period, and then it shall be the intent of the General Assembly that such funds shall be used to fund the Trauma Care Network Trust Fund.
Mr. Walker, is that two questions? Is that wording the language we need if it's going to go to the state general fund? And second, with the provision there that's added, is that creating constitutional issues with the legislation?
I'll have to beg the chairman's pardon. I don't know that I can answer the question. My concern is that there are funds collected at the local level then being remitted to the state general fund. I'm not familiar enough to be able to give you a competent answer.
Yeah, I mean, it'd be best if the Department of Revenue could look to this. I mean, we're working on the fly to do something. I don't like doing things on the fly that aren't able to be done on the fly well. To the author, I just have a concern about this. I don't have to impose this at, 8:27 p.m. on the 21st.
No.
It's a concern.
Mr. Chairman, if I could respond real quick, and I appreciate that, but I do want to caution. I'm adamantly opposed to revenue-based policing. I do programs against it where I go around. But when we toss this around, I want to be clear. Every time you say it, you're insulting about 90% of the men and women that go out there and do the job. Never is there a call meeting where a chief, a sheriff, or anybody else mandates the number of tickets, tell them to go out, write more speeding tickets, all this stuff. It doesn't happen in this job. It's happenstance. And with the conditions we're working under right now, with the manpower shortages we have even less time to do that kind of policing. So I just want to be clear on that, Mr. Chairman.
Let's stay on track. Do we have Senator Watts? You offered an amendment.
I'm in full concurrence with Senator Setzler about, and I don't know the wording, but if super speeder can do that, because there was a time from an appropriation standpoint, we used super speeder when the economy was down. We used it in the general fund. It is now, because that's my section of the budget, it is now all the super speeder money, which is done locally, right? That's where you're caught. You're caught on, Highway 80 or wherever, or the interstate. But the money's local. It goes to the Georgia Trauma Care Network. And the other money that goes there, by Constitution, is fireworks. And we split that with the Fireman's Retirement Fund or something like this, 50-50. But those are significant funds that fund Trauma Care Network, and they are underfunded still. Because the state has grown and we've had other trauma centers closed. Atlanta Medical Center is an example. So I agree. I share the concerns, but I think it can be done.
Why don't we do this? I've tried to avoid this all night because tomorrow is our last hearing, and we've got other measures to take up whenever we start tomorrow. Hopefully it's not 6 o'clock tomorrow. Currently it's scheduled for 4. We know how that goes. But we could hold over the bill to tomorrow and see if you can figure out how best to add that language, assuming that's something you agree with, if that's what the committee wants to do.
I'm not suggesting we hold this over. I don't want to do that, gentlemen. I think there's a policy question. I'm committed to the policy question. I would say, if I could, I strongly disagree with the premise that I'm insulting law enforcement by making the challenge. Because I draw a real distinction between law enforcement citations at a roadside stop and cameras. Right. I don't want to go on. I have a fundamental issue with cameras.
I understand.
I think it's different, and I think camera dollars could the dollars we generate going back towards serving our public in a direct way through trauma care is more consistent. I see it as different than a roadside stop. So I think roadside stops, go to the agency, cameras, trauma care. I'd be glad to offer this as a floor amendment, Mr. Chairman.
Let's do that. We have a motion to pass that was seconded. The motion to pass was made by Senator Watson. Do you want to move forward with your motion? You want to withdraw your motion? Move forward with the motion. We have a motion to pass that's been seconded. All those in favor of the motion, please raise your hand. Have 2. All opposed? All right. It fails 2-5.
Thank you, Mr. Chairman.
Thank you. Sometimes that's easier. All right. Senator Hatchett, let's go back on the agenda. Senate Bill 466. We're working off of LC 491737.
Thank you, Mr. Chairman.
Floor is yours.
Start with you. I've got the head of the Human Trafficking Division over at the Attorney General's office to help me testify to this bill. This is Ms. Hannah
Palmquist.
Senate Bill 466, as you said, LC 491737. This bill and the bill I'll present next both address the issue in our state where technology has outpaced the criminal code, and there's a need for, addressing certain issues. Particularly with this bill, Senate Bill 466, right now in the state of Georgia, when someone creates AI-generated child pornography, for example, and is charged with the sexual exploitation of a child, it is a defense that it was created using AI, essentially, and that it is not the child itself, but just looks like the child. What this does is it closes that loophole and prevents that defense from being used so that these individuals can no longer get away with creating AI-generated child pornography.
All right, do we have any questions from the committee for the author bill? There are people who signed up to speak for and against the bill, so let's start with questions for the author. All right, is there anything you want to add right now?
Thank you, Mr. Chairman, members of the committee. Simply to say that it really is that simple. This is just to close a loophole. Right now, child's faces can be morphed onto images, and that's not prosecutable under the law. We see it happening every day. We hear from law enforcement that children are being exploited because their exploiters are using artificial intelligence to morph their faces onto sexually exploitive images, but the damage that it does to the children is the same as if those images were distributed and they were, in fact, authentic images. So we're simply asking to close that loophole.
All right. If you don't have any questions at this time, we'll move on to those that want to speak on the bill. All right, first up will be Chelsea Thompson with Frontline Policy. Thanks for sticking with us.
All right,
Thank you, Chairman, members of the committee. I probably didn't have to sit down, honestly. Just gonna keep it real brief. So I'm Chelsea Thompson. I'm General Counsel of Frontline Policy. We just want to offer our support and thank Senator Hatchett for bringing this piece of legislation. So in closing this loophole and really protecting our children, also prosecuting where necessary. So thank you.
And also Mike Griffin with Georgia Baptist. It's been an exciting night in Judiciary, hasn't it, Mike?
One of those days.
It is. Has been one of those days.
It's,
wait till tomorrow.
Into my 17th year. I've had a few nights down here, it seems like. My name is Mike Griffin. I'm the Public Affairs Representative with the Georgia Baptist Mission Board. I also work under child protection policy and whatever I can do in those areas. And we like this legislation. We think anything that creates a stricter enforcement when it comes to pornography or anything, whether it's AI or whatever, that this is a big help, and we need that, and it helps protect our children, protect others, and we need to crack down on this industry absolutely as much as we can, because we're downstream from what's happening is having a extremely negative impact on our society, particularly on our children. We're already looking at situations where I have gotten data where 52% of child sex abuse today is even peer-to-peer. And so anyway, any type of enforcement that we can do to make this more stricter and to have less of these issues regarding pornography is very good. And so we support this legislation, and we certainly do appreciate Senator Hatchett bringing this forward. Thank you.
All right, thank you, Mr. Griffin. Next, we have Miss Maisie Lane Girton. And I said you were opposing it, but you're always fair. You always write what you're going to do. You said comment, so I don't know what that means, but.
I mean, I'm on the opposed page.
They're on the opposed page, to be fair.
Maisie Lane Girton, Georgia Association of Criminal Defense Lawyers. Always fun to be the person here to say, we need to take a second look at this, because as we begin to consider these the creatures of AI that are coming into our criminal legal system in these ways, I take exception to what was said about the harm to children with respect to AI-generated images. The harm to children, as I read 1612-100, is that is a child is put in very awful, compromising positions, photographed, and then those photographs are used for the prurient experiences of people. As repugnant as that is, it is somehow less repugnant to me to think that you could take pedestrian images, not necessarily ever harming a child, turn them with some AI technology into something that is equally of concern to us when we look at it, but having not harmed a child. To me, there ought to be some distinction, and as we begin to wade into this AI space, if we begin with this false concept that harming an actual child is tantamount to taking disparate images scraped from different parts of the internet and turning it into something is the same, I think we're going to break down eventually. And my comment is because I'm not sure that my concern is addressed by modifying this particular bill. I understand the desire to not have this sort of AI defense. I do not think this is a loophole. This code section contemplates a minor, a person under the age of 18 years old, being used in these deplorable ways to create imagery. It does not contemplate scraping together, like I said, potentially pedestrian images, although I do acknowledge that there could be a situation where you take a picture that was created by harming a child, morph it into something different, and then we do have a problem here. But this is a broad brush answer to what is becoming a very complex reality when we take these AI concerns and realize their impact on the criminal legal system. I mean, I was very candid with Senator Hatchett as I discussed this bill with this proposal with him. I'm the last person who wants my kid's head interposed on one of these horrible images. I mean, I'm not going to pretend that there's not something grotesque and troublesome here, but to pretend that treating a child in this way and crafting some kind of image are the same is, to me, a disconnect that you ought to consider seriously before you begin making these kinds of decisions about how AI applies to defenses and or crimes in our state.
All right. Any questions of Ms. Skirton? Do you have a question, Senator Jones or Sessler? Sessler, your mic 7.
Yeah, I don't know how to do this. I was just going to ask the rep for the Attorney General's office to speak to that concern. I mean, we're hearing this. I just want to hear the kind of direct response to that.
Absolutely. So speaking first to the harm is in the distribution. The harm is in the existence of the photographs. The problem is when you have an artificial intelligence image of a child and a real image, we can't tell the difference anymore. So the harm is the same to a child if their real nude photo is distributed online, and if a photo online is distributed them where it was morphed using artificial intelligence. Therefore, the harm is the same. I also want to clarify when we're talking about the distinction of harming a child and taking their photo and simply having an artificial intelligence photo of them. If someone molests a child and takes their photo, I charge them with child molestation and child pornography. Child pornography simply does that. It simply punishes the pornography. So there is additional punishment when there is physical harm. This would treat the mere images the same. We have other statutes that make it more egregious to physically harm a child, not the pornography statute.
Mr. Chairman, appreciate that. We're saying AI. I'm trying to make sure we're clear on this. It wouldn't require an artificial intelligence system to do this. You could use Photoshop or something like this. So, our legislature tends to use AI as sort of emerging technology, but it's kind of fuzzy. What this really means is, by any means, taking an image and imposing it on a image that's not the body of the person and distributing that. Yeah.
Thank you, Senator.
Okay.
That's exactly correct. And I also want to clarify that this statute only pertains to real children. This is not imaginary children created by artificial intelligence. This is real kids. We look at their face and we know who it is. And we have a lot of real world examples happening that law enforcement's getting these cases and there's nothing they can do about it. People are taking teenage girls' images off of Instagram, creating pornography out of it and selling it for profit, and there's nothing that we can do about it. People who collect child pornography can simply turn to child pornography created with artificial intelligence, and there's nothing that we can do about it. We've seen children be extorted with images because they know if their images are put out onto the internet, nobody's going to know if they're real or fake. So to that child, that distinction doesn't matter.
Thank you, Senator Jones.
Mr. Chair, I always thought that you just could not have pictures of children, that you could not have basically even naked pictures of children. If this is, even though it's AI, wouldn't it still just be it would be a child? I mean, wouldn't it? So where's the loophole? Like, what cases happen where somebody has a bunch of AI photos with naked pictures of pictures of children and the police couldn't prosecute it?
Thank you, Senator. That's a good question. And someone could argue that it could be prosecuted under the statute, but the reality is we know that we have to strictly construe statutes in favor of defendants, and the statute is silent as to whether morphed images count. So I think that the better rationale is to assume that if we tried to prosecute someone for artificial intelligence, we likely would not be successful. We would have an issue when that statute is narrowly construed. And these cases that we're speaking about, they are out there. Law enforcement just isn't taking the warrants. District attorneys' offices aren't prosecuting them. They're all calling around to one another saying, what are y'all doing with these cases? We don't know what to do, because the statute doesn't speak to it. So what we're seeking to say is, within the statute, it is not a defense to say that it's morphed. Furthermore, I want to point out a really problematic issue that occurs if we don't modify this statute. So because it's not clear that we can prosecute AI, how do we handle the defense when a defendant has real child pornography but goes into court and says, nope, it was AI? And we can't look at it and tell if it's real or AI. So then it becomes a defense that then the state can't even respond to, because today it's indistinguishable. So for many reasons, we have to be able to tackle the AI too. But to your question, I certainly think someone could argue it under the statute, but I think if we narrowly construe it, we have to say the statute is silent as to it, and so law enforcement right now is not comfortable utilizing the statute to charge it.
But this would not change the penalty that exists today, correct?
Correct.
This bill refers to 1612-100, and I will just read part of that to you all. It is unlawful under 1612-100 to coerce any minor, which is defined as a person under the age of 18 years old, to engage in or assist any other person to engage in any sexually explicit conduct for the purpose of producing any visual medium depicting such conduct. That necessarily is actual harm to a child. I understand the difference in child molestation. I'm not talking about that kind of harm. I'm talking about the harm that is necessary in order to depict a little person's body in a sexually explicit way. It is also unlawful, let's go down to paragraph 5, for any person to knowingly create, reproduce, publish, promote, sell, as has been described, distribute, and it goes on, a visual medium which depicts a minor or portion of a minor's body engaged in any sexually explicit conduct. This is the harm I'm talking about. This is the harm that the children suffer when these images are taken of them. There may well be later harm caused by the distribution of an image that is embarrassing or somehow brings emotional harm to a child, but there is actual harm happening when these photographs are created under certain portions of 1612-100 that also may rise to the level of child molestation, might also rise to the level of aggravated child molestation. I am not, there's no problem with charging all of the harm that happens. The concern with this legislation is that it minimizes the harm happening to the children when these pictures are taken of them in these sexually exploitive ways, to then say that someone who creates an image from whole cloth, as has been said, you don't even have to take images of real children. As long as it apparently looks like a real child, you've created completely from a computer program, you're equating that then to harming a child in order to take their picture this way. That's my warning to you.
Any other questions from the committee? All right, you have anything else before we close it out? No one else out to speak on the bill?
No, Mr. Chairman. Just ask for favorable consideration.
What's the pleasure of the committee? Motion to pass from Senator Hodges. We have a second from Senator Setzler. All those in favor of the motion, please raise your hand.
That includes you, Senator Hatchett.
It is unanimous. Thank you. Last bill on the agenda. Senate Bill 493, working off a committee substitute, LC 560150S. Is that what you have?
560150S. That's correct, Mr. Chairman.
All right, the floor is yours.
Thank you. Once again, this is a bill that deals with advancements in technology and how they have outpaced the current criminal code. What this bill seeks to do is make it a crime for a registered sex offender to use an unmanned aircraft or a drone to photograph or video a child or a person without their consent. The reason I'm bringing this bill is obviously when someone is on the registered sex offender list, they have to, and they're required to register, they have to put where they live. Their photograph is on the registry, and that is a public policy and public safety issue so that people know who they are, where they live. Well, when someone uses a drone to fly around a neighborhood, that drone is kind of it could be protection for that person so that alarm bells don't necessarily go off. You don't know who's behind the drone. And there were some instances, one in particular in Rhode Island, which is what originally brought me to this idea, where a registered sex offender was using a drone to capture photographs of a woman in her bedroom and bathroom. They finally caught him because she kept hearing a buzzing noise, and it was the drone outside of her window. So what this does is it makes it a crime to use a drone in that way. The reason we have a substitute, and I have someone here that helped me draft it. It actually went into Chapter 8 of Title 42 of the Official Code of Georgia relating to probation, and it would create a new paragraph that just applies to those sex offenders who are on probation, that it would be a condition that they would be prohibited from possessing, owning, or operating an unmanned aircraft system as defined in Code Section 42-1-18. The reason that was added is because the bill, as it was originally drafted, dealt with the intent to photograph a minor or a person without their consent using a drone. That intent piece would be a little bit difficult to police, but with this committee substitute, we feel like we've been able to cover everything we need to in order to enforce this.
I have a couple of questions. Looking at lines 48 through 51, is it currently illegal for a person to use an unmanned aircraft system to photograph someone without their consent?
Someone? No. It is not.
And so your bill, second question, line 50 says any person. It doesn't say minor. Is there a reason we make it any person versus limit it to a minor when you're looking at registered sex offender?
Because registered sex offenders are not specifically, the crimes that they commit are not always against children. So they are also against adults as well. And for the reasons I described earlier, the anonymity that comes with flying an unmanned aircraft is a safety concern when you are flying around a pool or a park, or I had a drone fly over my house this summer. There's a layer of protection that a drone can provide to a registered sex offender that I believe we need to prohibit this technology from being used for them to photograph anyone.
And that's not the subject of your bill, but I wonder if it ought to be illegal for anyone to photograph somebody without their consent with a drone, not just a sex offender. But
I think that would be difficult to do because of photography, for real estate, for
sure,
wedding videos.
I guess there's less expectation of privacy in the air over a public street, right?
Right.
It wouldn't work very well. You have some questions, Senator Setzler.
I was just going to say that to the chairman's question. In 2014, we had a drone bill that we spent for hearing. One of the most complex issues that I ever saw in a judiciary committee. You have freedom of the press. You've got, it's even your flyover rights. So it is extremely complex. I think if you keep it to a sex offender, I think we're probably in safe territory. I think the ability to have a drone over your property that looks into someone else's property, looks into their pool, there's all kind of things that it opens up. Sure. If you try to take out of this narrow bill, I think the narrowness of a sex offender keeps us in safe territory.
Any other questions from the committee for the author?
Yeah, I'm sorry. I did want to ask on line, Mr. Chairman, on line 52, the modifiers throughout this has been person required to register as a sex offender. On 52, it says any person who commits an offense of knowingly possessing. Do we want to say any person required to register as a sex offender pursuant to 42-112? Does that modifier need to be there to make sure we're just talking about those folks? Because otherwise, I think it throws this much broader than just that, and that's probably not your intention.
I think when you go down to line 54, it says in violation of paragraph 1, which is specifically tailored to only capture registered sexual offenders.
Okay. I'm just trying to catch this as we go. Thank you, Mr. Chairman.
All right, there's a couple other people signed up to speak on the bill. If you'll sit tight. We first have Ben Lund from ACLU of Georgia. Welcome back to the committee.
Appreciate you, Mr. Chairman. Don't want to take up a whole lot of time because I actually don't have a whole lot on this bill, but I just want to start as a preface in saying that I recognize that I'm coming up here to advocate for what is a very disfavored group of individuals in Georgia treated in law in many ways, and that's people on the sex offender registry. I don't take any, umbrage with doing that. It was, something I did as a criminal defense lawyer, and it was out of a recognition that even if somebody has committed horrible crimes in their past, after they've completed their sentence and then they're on the registry, they are still people who are worthy of, the life they have, and also have to have an ability to live their own lives. I think that's important to remember as we're going through, and that means the opportunity to earn a living. So when I come to talk about this bill, most of it I don't actually really have a problem with. It's actually just Section C, the section that you highlighted, Mr. Chairman, regarding as a condition of a person's remaining on the registry, they're not going to be allowed to own a drone for these purposes. And I think, and I was actually prepared to kind of give a procedural history of the 2014 bill, because I think that was a really good representation of not only federal and state law concerns, but also the federal and state constitution in terms of what can be implicated by restrictions on a person to take pictures without their consent with drones. Exactly as Senator Setzler said, freedom of the press, freedom of association. There's also federal laws regarding illegal restraints on trade, and that's a person's ability to complete their trade. So what I wanted to flag for this committee is there is a case, it's a 2019 case, it's Park versus State, that's 305 Georgia 348, 2019, where we looked at electronic monitoring for people who are on, again, and this is a lifetime infirmity that person on the sex offender registry has. At that point, under Georgia law, they would have to be electronically monitored, and they have to pay for that monitoring. And former Chief Justice Melton wrote an opinion that was unanimous in its holding that was a manifest injustice and was an illegal restraint because it was an unlawful search. So that was traveling under the Fourth Amendment. But I think everything about that case, if you replace it with the First Amendment applications, the First Amendment rights or 14th Amendment rights that we just kind of talked about, the analysis is the same. And so I think Section C takes what is otherwise an expansion of a law that kind of reflects changes in technology into something that is wholly constitutionally suspect. So that's why I've stayed here till 9 p.m. tonight, was to say that I would ask this committee to consider the removal of subsection C in those lines, because I think that under Park, that would be intensely constitutionally suspect to have that allowed. And with that, I'll yield for any questions.
Any questions for Ben? You asked for him, Senator Setzler.
I'm trying to read this and understand the difference between C and B. I mean, B is a 1 to 30 felony. C creates the 10 to 30. How is this? I'm just trying to process all this. How does that operate differently?
Right. So in that, when we're talking about, we're having what could be incidental photography of individuals without their consent that happens through drone proceedings, or like it was exactly what you talked about with real estate and other things, versus the actual intent to photograph a minor, which is what would be considered in subsection A. And so that also may possibly be constitutionally suspect. I say that because it is kind of a newer law, and I did check the reference on that bill, and there hasn't been any cases, any challenges to that bill. I would say that probably because that law has, up to this point, if we use this legislation, was a misdemeanor offense. And so sometimes things that dogs would bark if it was a felony offense may just not be charged or have an opportunity to be challenged in the same way that felony offenses are.
I'm sorry, that wouldn't, respectfully, it didn't answer my question.
Okay.
What is different in B than C? I mean, I see the difference in the penalty. B is affecting what, C is affecting what? I'm trying to understand that, because you like B and don't like C.
It's not that I like B. I'm just not here to talk about B. Okay. And Senator, I think that is important, because I also think that section probably may fall in the same restrictions that Park has. I think that Section D is actually a lot closer to what this, Section 2 of the bill is actually a lot closer to what this committee could do in terms of having that be a condition of probation. That was something that was specifically said by the court in Park would be something that would be okay. It was about the lifetime infirmity that exists with the registry requirements, that having those kind of restraints weren't something that the court was willing to do then.
But isn't it true if they were, say, a lower level sex offender like child pornography or statutory rape or something like that, they could come off that in 10 years and would not be subject to this anymore, correct?
If they came off of it, and that's and that wasn't a part of my practice, so I can't speak to like the realistic expectation of somebody to become off the registry. I appreciate your question, Senator.
Any other questions from the committee? All right, thank you.
Thank you, Mr. Chairman.
All right, Ms. Maisie Lane Girton, you want to close this out?
Well, yes, I was thinking I could say ditto. But,
Well, you can say ditto,
I can't,
but
though, because
I know
Ben
you have a
left
job to do.
alone. The not less than 10 years. So I am looking at line 55, and this is in that subsection C that you all were just talking about with regard to the intentional photographing, observing, following, or contacting a person without their consent. You know, this is one of those situations where you can, let's say this person is a registered sex offender and lives right outside of Piedmont Park, and on July 4th goes outside to capture the end of the Peachtree Road race because it's such a just phenomenal scene to capture. Now they are subject to a minimum of 10 years of felony punishment under this code section. Like, when you think about our criminal code in the aggregate, you can harm someone severely, aggravated battery, aggravated assault, without this kind of exposure to punishment. And there is no nexus here. So, you know, Senator Setzler, my answer to your question of why am I less concerned with subsection B than C, one is the sentencing scheme. Two is we already have this provision in the law that you see at lines 32 through 34, wherein a sexual offender that's required to register cannot intentionally photograph a minor without the parent's consent. And the expansion that I see happening with Senator Hatchett's bill is taking into consideration that we do have these new technologies where this kind of behavior could happen more surreptitiously. However, when we switch over to C, we are really wading into the fact that we're in a public space where we do not have reasonable expectation of privacy, and there's no nexus here between any kind of sexual offensive sexual behavior or intent or conduct, and the sentencing scheme tied to it is just extreme.
You have a question from Senator Jones, is that right? Okay.
So with this section here, I think I know the answer to it, but this section here on which talks about the offender pursuant to code section 42-112,
Yes.
does that include more than just persons convicted of, let's say, a sexual assault against a minor?
Yes.
Who has to register? Who are we talking about here? What type of person, what type of offenses have to register? It's more than just a minor.
All kinds of offenses have to register. I mean, stat rape has to register, even if it's a kind of a, so there is another bill happening right now with respect to the registry. You could have a 19-year-old, 15-year-old, consensual sex, but it's statutory rape, and that person has to register. And if you do the math on the way we see those cases play out, if that were to happen when, let's say she's 19, he's 15, takes a couple years to get through the system and get the conviction when you're like, I don't know, 22, 23, 10 to serve 2, now you're 32, 33. And then you have to wait under our current law. If you're a level 1, you could petition for removal at that point if you knew to do that. If the law changes as is proposed right now in another chamber, you'd have to wait another 5 years, so potentially 37, before you have a chance to come off the registry. And all that time, that person who had consensual sex when they were 19 years old would be subject to this. Let's say they become a photographer. What if they need stock photos of a beach scene, of a park scene, of these very innocuous public scenes where they are not there's nothing here that's a nexus between the underlying sex offense. It's just people out in a public space at an airport. There's lots of images you can imagine. We could all sit and imagine where no one in that scene has reasonable expectation of privacy. No one would be harmed by anyone taking their picture, irrespective of whether they've committed a sex offense in the past or on the registry. You could have I see the potential for a First Amendment violation here, although, of course, we have to litigate that, like we've talked about earlier in the evening. You never know what litigation's going to come. But when you're in a public place taking pictures of people without a reasonable expectation of privacy, that's something you got to be concerned about.
Here are questions from the committee. Thank you.
I just have a technical question for the author, Mr. Chairman.
Come on back up. You can close this out, Mr. Floor Leader.
I'm having a brain block here trying to read this and understand Section B and Section C. I just don't understand what Section C is different that makes it more severe. I'm just trying to understand the bill. I can't.
Section B is just photographing a minor without the consent of the parents. It has nothing to do with the drone.
Okay.
Section C has to do with an unmanned aircraft and taking photographs of someone without their consent, intentionally taking photographs of someone without their consent.
So if a minor is a 1 to 30 without parents' consent and taking pictures of adults is a 10 to 30 with a drone, I'm just trying to be consistent. I'm trying to write good law here. I like you're doing something with this bill. I just don't know why it's a 10 to 30 if you're filming adults with a drone, and it's a 1 to 30 if you're filming kids.
So it would also be Section C applies to children and adults.
Oh, I understand, but I'm saying, but because it can apply to adults, Section 1 is a 1 to 30 applying only to kids, not using a drone, but using some other, some kind of lens or whatever. But because it's a drone, if the modality you use to photograph somebody is a drone, to include photographing an adult, the minimum is 10 years. That just doesn't seem. Maybe they're both 1 to 30s. But why is it a 1 to 30 if you film a kid with a telephoto lens, and it's a minimum of 10 if you film an adult with a drone? That doesn't seem. That almost seems backwards.
That was just a policy consideration that, and you're the first person to bring that up. So, you want it to be a harsher punishment?
No, I think one is I think this is just me speaking as a member of the committee, Mr. Chair. The lower end of the fact pattern. What's the least severe thing that could trigger this statute? It's pretty low in terms of criminality. 10 just doesn't seem. You almost lose me on the 10. If 1 to 30 is the world we want to live in, because the high end of the fact pattern is really, really, really bad, make it a 1 to 30.
Well, isn't it a high aggravated misdemeanor the first time you do it?
Yes.
So
for just photographing.
For just photographing.
Right.
Is there a reason that we want to have a higher punishment for violation of C1? Do you have a policy argument for that?
I just think it's because the intent there to go out and purchase this type of technology, fly it under the, disguise of, having a drone, you're anonymous. It would be very difficult to catch this person because 9 times out of 10, you don't know who's flying the drone. It's kind of someone who is already a registered sex offender, has already been through the criminal process, knows the rights, and would really have to take significant steps to commit this type of crime, which is why we set the penalty where we did.
Are any other questions from the committee?
And Mr. Chairman, one thing that I would like to point out is in Section 2, it's on line 59. It says, is amended in subsection A of Code Section 42-8-35. That should be subsection B. If somebody could offer, I guess I could offer that amendment as a member of the committee, but would like to have that changed.
Maybe next time you'll just draft it correctly the first time and not keep us here so late.
You're exactly right. This was. I'll work on that.
Let's see if we get a motion to pass first. Oh, Dr. Watson, let me turn your mic on. I am. Wrong microphone. Hold on. That one. Go.
Yeah, okay. Do pass. Second.
By committee substitute and a second from Senator Hodges, a motion from Senator Watson. Do we have an amendment? Senator Setzler.
I don't want to Shanghai the gentleman's bill. I feel like this stuff moves so fast.
I know.
I don't know why we can't add drone to the definition of photography, observing using a drone. I don't know why it can't be in the same framework, and you should say you're not capturing a photograph, but the very fact that you're using a drone to observe something, that gets you into Section B. If you're grafting in adults in addition to kids, it does accomplish your objective of saying, you know what, it's not just, you're in high and elevated land, first offense, your felony land, second offense. Usually, when you come from high and aggravated to felony, it usually goes from high and aggravated to 1 to 5 or 1 to 10. We're going to 1 to 30. That's a massive jump. You're trying to pick up adults with the drone thing. I get that, because you could fly it up into a window 4 stories high where folks would have an expectation of privacy they may not have on their back porch. So I see what you're doing. I just don't understand why the penalty provisions of the drone thing, which adds in adults, not kids, shouldn't just be the same as you have in Section B and just go with it. I mean, you're bringing in a 1 to 30-second offense. So if you have some creep that does this multiple times, maybe claimed first offender the first time, it may be the third hit. I mean, I see you want to hammer them hard. I just don't get the 10 to 30 at the gate with a drone for an adult. That seems, I mean, you almost lose me just on the penalty side, even though I agree with your bill. We just need proportionality is all I'm trying to look for.
You have your response?
I mean, I understand your argument. I respectfully disagree. I think these are good penalties for that type of offense. But
Senator Setzler, are you offering at least on line 59 to change A to B as an amendment? Yes, sir. Mr. Walker.
That amendment would not be necessary. It is, in fact, subsection A.
We had it right to start.
so I think subsection A are the required. Yeah, if you don't mind, Philip Henson.
Hey, good
Hey,
evening,
Mr.
everyone.
Henson.
Philip Henson, the Government Relations Coordinator for the Department of Community Supervision. 42.835A, those are the general conditions of supervision that the court can order for any supervisee or any probationer. 42.835B are the additional conditions the court can order for a sex offender. So those would be, I think it would be paragraph 5 if you put it in B. But if you put it in A, the judge can apply it for any individual on supervision if they felt like it.
Mr. Walker.
That being the case, it would be a more complicated amendment than changing A to B, but I'm happy to accommodate if that's what's needed. There's not 17 paragraphs in subsection B, so we would kind of have to we'd have to kind of fix lines 58 through 64, which is not an issue. I'll take a moment to do it.
Is that the amendment you want to offer?
Yes, Mr. Chairman.
I just want to get a sense of the committee. I don't want to offer some, and I'd like to have the author. I don't want. He brought the bill. I didn't bring the bill. I'm not trying to light his bill up and take his bill away. I can't understand why a drone photo of a person's a 10 to 30 and a second offense photo of a child is a 1 to 30. I don't.
Let's do this. Let's go. The amendment that was suggested by Ledge Council. Do we have you offering that amendment?
Yes, Mr. Chairman.
Is there a second for that amendment? Second for Senator Watson. This is one of those times where Ledge Council will craft the language consistent with the intent of the committee. Does anybody have any objection to that? All in favor of the amendment, please raise your hand. The amendment, anybody opposed to the amendment? Amendment's unanimous. Now going back to discussion, and I think the only way to do this is to, if you have an amendment you want to offer, and then that's the only way to really poll the committee.
I don't want to offer an unfriendly amendment.
Okay.
He brought this issue, heads up issue. We do need to address drones. Looking at.
And what we need to do is, if the bill's going to move, we'll go back to the online motion. Then you can get with Senator Hatchett, and if y'all want to consider any floor amendments, this bill has a long ways to go, like all our bills right now.
I'd be happy to talk with Senator Setzler.
All right, back to a motion to pass by committee substitute now as amended. All those in favor of the motion, please raise your hand. Any opposed? That, we are adjourned. We hit the limit. Oh, what a day.
Signed.
He's